That's in 2018, the Supreme Court had directed all the states to not to appoint any politicians as chairman of state pollution control boards, and directed to frame guidelines in accordance with the Supreme Court monitoring committee appointed monitoring committee observations, and MG came in a report. The state had not followed it. Twice it was rejected. Ultimately, my lords, on 29/11/23, this Honorable Court approved it. Now, subsequent to that, they were once again changed in December 24, and now they have appointed a politician, sitting MLA as a chairman of State Pollution Control Board. That rules, I've challenged it, and that stands over to tomorrow, 14/11. Now, I have also filed this challenging this appointment of sitting MLA. The Lordship may kindly take it up tomorrow along with that matter.
You file it and get the.
No, I have already filed it.
Remove the office of the release it.
But the other matter is scheduled for tomorrow, my lords.
Maybe we'll see when both will list together. You remove the office objection?
No, there is no office objection. It's already been
Then
filed.
there is no question of mention.
There
is no
if it is heard together, that will be convenient.
There is no office of be listed within 5 days. Pursue with the office, yes.
That is supposed to tomorrow, petition. And the contempt petition was listed in the case about 850 plus. But can be taken up with the.
What is the urgency?
There is between a matrimonial proceeding. Matrimonial proceedings are going on in the trial court.
Tomorrow not possible. 21st February.
Serial number 82.
Yes, Mr.
Serial number 82. Yes, a matter wherein the petitioner.
Which number?
Posting. But the petitioner was granted mining lease for the purpose of extraction of sand. Due to a government project of the said land submerged in water, there is an alternative land available. The petitioner has made an application for sanction of the alternative land. That application is pending consideration. Now, as if the same was not enough, the department is demanding. Therefore, may not be.
10th February. Not 10th March.
This is the case with regard to the grant of land under schedule caste and schedule caste lot. This petition has been dismissed on the ground that there is a dilemma. By taking the undue advantage of the respondents are trying to eliminate this property. Appoint the writ appeal.
12th March. Yes, Mr.
Serial number 82.
82.
We have filed an ID for that. The annexure, it was a certified copy of the tender document. Online document. Also mentioned that in
No, you deal with the office, yes.
Serial number 30.
Yes, Mr. 65. Yes, Mr. 65. 65 you want to mention, will not break the line. Yes, Mr. You want to mention? For what purpose? For what purpose?
Find the memo for withdrawal.
Withdrawal, which matter?
Memo posting on the matter.
18th. 18th at 2:30. Yes, Mr. 60, yes. Pardon?
Disabled to hear the matter.
To be, not to be placed before the bench where one of us, Honorable Mr. Justice M.I. Arun is a decador, is a member.
Serial number 30, madam. Serial number 30.
30.
Number 30, it's number 1, madam. 2 weeks time will be from the other side.
Delay, will issue notice.
Notice is already.
Already is 2 weeks time.
You,
Then 17th March.
Your Lordship, serial number 35, Your Lordship,
35, yes.
for the petitioner seeking for a small accommodation in that matter, Your Lordship.
Tell your date.
So,
Which date?
any date convenient to your Lordship.
18th March. 18th March.
Gratefully, Lordship.
Serial number 25.
Yes, Mr.
Serial number.
Yes,
I'm sorry, the serial number 38 has been fixed today, my lord. This is regarding the BBMP land which is being auctioned and sold. Can it be taken up bit ahead of the list, my lord? Because
38 will reach, otherwise we'll take up.
very well.
If doesn't reach, we'll take.
Serial number 25.
20,
25. I'm appearing for appellant. Place for a short accommodation.
25, what do you want?
Short accommodation.
So take on 21st March.
Serial number 62, my lord. I appear for respondent number 5 and 6.
62.
Statement of objection, my lord. Get instruction. Not accommodation.
What is it about?
So PIL file will
Correct. About what?
some unit, manufacturing units.
My lord, it is shifting of a chicken waste processing unit, my lord, because it's causing pollution.
Present the panchayat, my lord. For certain documents, my lord.
18th March.
Serial number 53. While Wakalat along with the university. Withdrawal.
53.
Lords, my compliance affidavit also may be taken on record. My lords.
53, while learned additional government advocate Srimati Pramodin Kishan tenders the affidavit of compliance, which is taken on record. On the other hand, learned advocate Mr. So-and-so seeks permission to withdraw the contempt petition by filing memo dated 13/2/25. In view of above, the contempt petition is dismissed as withdrawn.
Malats, kindly, Malats.
Serial number 30.
Compliance affidavit may be taken on.
Serial number 16, Malad. Fresh matter. And a little bit indisposed, week's accommodation. Serial number 16. I'm a bit indisposed next week,
Next week, it will go to,
20th or 21st.
then go to 24th March.
47.
47.
Both the parties are under mediation procedure.
My lords, I appear for the accused in serial number 47, my lords.
47.
The matter is in the mediation.
It was jointly stated by learned advocate to both the sides that the parties are engaged in the process of mediation. In that view, stand over to little longer, 26th
Yes.
March.
Yes, my lords.
26.
Grateful. My lords.
Serial number 48.
48.
While I'm 2 weeks time may be there.
Other side is no objection. Inform then it will be posted on 23rd March, 24th March. Once you-
36.
But inform the court officer that you inform the others.
Serial number 36,
Hmm?
list 1 lordship, appearing for the petitioner.
30,
Is done one lordship.
36.
36.
So what is the request?
Seeking short accommodation. Senior is
Short
done.
accommodation. It will go to 27th March.
My lords, in list number 1, serial number 13, my lords, the arguing counsel not being in station, it may kindly be adjourned, my lords.
That is 777 of 25.
777 of 25, exactly, my lords.
So can it go to 27th March?
Yes, certainly, my lords. At your lordships.
My lord, serial number 5, my lord.
Aye.
Contempt petition, my lord. I pray for 2 weeks time, my lord, because they have filed a writ petition before the single judge, my lord. And that is kind of pending for consideration today only, my lord. They are seeking for modification of some orders, my lord.
At the request of learned petitioners, stand out. When do you want?
After 10th, my lord, next month.
After 10th?
Yes, my lord.
After 10th, 17th February? No, sorry, 17th March?
Much obliged.
Yes,
Serial number 37, my lord.
37. Yes.
Senior counsel is held up at Darwad bench, so.
Pardon?
Senior counsel is accommodated at Darwad bench. I mean, held up with Darwad bench, so.
No.
Sir, we have informed the.
That is not the ground. 96 method, yes.
The other mentioned through this is, sir.
List number 2, that's tree matter.
It promised him 11. Get it. At 11:30, at 11 o'clock we'll take it.
11.
Get the papers lying on the table. 11. Papers are lying in my table there.
Oh,
Just wait for 10 minutes.
yes, Mr.
So fresh content matters, seal number 1. Yakshata M. Patel.
Portion of the trial for order.
Over to the bridge.
Page 42, operative portion of the trial for order. The complainant is a patent holder of an underlying technology for digital ticketing system integrated in a public transportation. So we had received orders that the accused shall not use that feature until the disposal of the case.
Notice. 18th March.
Seal number 2. Sir HR Shori.
Lords, I appear for the complainant, please. Lords, page 19, what's the operative portion? Lords, an inquiry was supposed to be
Notice
concluded.
19th March.
Please. Privileged.
Seal number 3. Mr. G.S. Venkata Subra.
At page 25, where Milord direction is Milord issued to Milord the enter in book 1 of pursuant to the sales certificate issued in my favor. To within 2 months, Milord compliance ought to have been done. 19th March. Notice.
Seal number 4. From Madhusudan M. Seal number 4. Madhusudan.
Pass out.
So 5 is urgent. Seal number 6. To Sunil S. Narayan.
My lord, appear for complainant, my lord. Page number annexure A10, my lordship. The learned single judge has directed the accused to pass an order, my lordship, on 6th February 2024. But the accused has been not passed any order, my lordship. Page number 14, annexure A, my lordship. The Tahsildar order has been set aside by the learned single judge and directed me to appear before the first respondent on 6th February 2024, my lordship. Page number 14, my lordship.
Following directions. The order of learned single judge dated 10th January 2024. While disposing of the writ petition, are brought under the contempt jurisdiction for their alleged breach, then court is taken. Learned advocate Mr. So for the petitioner paragraph would submitted that directions are not complied with by the authority, and other directions in the nature of restoration of entries, etc., are also not complied with. Full stop. Bare perusal of the directions paragraph go to show that learned single judge is not prescribed in time limit for the purpose of compliance and for the competent authorities to act according to the directions. In that view, it is not possible to at this stage that any of the respondents have committed contempt, much less a willful contempt in not complying with the direction. Time limit is not set for the authorities in that regard. Very well. At the same time, since it will be right that the directions of the court are complied with, it is provided that the directions shall be complied with within a period of 8 weeks from the date of receipt of this order by the authority, by the respondent assistant commissioner, by the authority concerned, failing which the petitioner will have the cause of action to file contempt petition against it in respect of non-compliance. With aforesaid observations, the present contempt petition is not entertained and discussed. Well, learned advocate Ms. So appeared through video conference. Yes.
List number 2, seal number 1.
Here for the petitioner.
Both the orders in earlier IA will be available today. They're already ready. That's to be. Now this will be number 8.
IA number 8.
IA number 8.
I number 8 in the.
IA number 8.
What is included?
What's this two? I know, also the filing. But it not we can do. Tell what is that? No, 5 and 6 and 7. Yes, 6 and 7. What is the other? Number 2. 2 on the 2 also. 2, 6 and 7. Nimdu I number. Nimdu I number is 8.
I number 8.
8 of
24.
Where is this movie?
Compensated plantation or BMRCL is how far away? How far away? Only my problem. Numbers in the either another case.
This rail infrastructure development company and this rail are both different.
Different.
I'm sorry, not the IA number 2, not the. Can we take lead? IA number 2 orders would be passed.
It is already passed on that day, available today.
Very
Will
well.
be
We
available.
uploaded today.
Very well. I'm ready.
Today.
I'm ready.
Sure.
IA
You are
number.
appearing in 2. 4, in 4 also you are appearing.
I number 4 is K right.
AG appears.
4 is also disposed of, that will be also available today, uploaded today.
Please.
In that, we have said that FIR shall be taken to its logical end. and 528 trees which are found to be unsightly cut at the inspection, we will compensate it by planting 5,000 more trees.
Please.
Please.
Deeply grateful.
Please.
That's in I number 4.
Not your.
Okay.
That's in respect of.
If you want to plant, you can plant.
We won't.
Manoj, Manoj, in so far as 5,000 planting trees is no problem, Manoj. The principle should not be if somebody else cuts, somebody else should be punished, Manoj. We'll plant 5,000 trees, Manoj, that's a good thing. But only thing it should, the people, as you also said, the perpetrators should be punished.
FIR is filed, you can take it, you pursue it.
We'll pursue that, Manoj. But
All
only
concerns will pursue it. That's-
Lord, even in OM, my Lord, those in respect of those, my Lord, felled, we have, my Lord, directed to, my Lord, planned, my Lord, make compensatory afforestation. We are doing it, my Lord. We're doing it.
Lord, it'll be the order of that date.
Please.
Order of 10-2, but to be uploaded.
Please. Number 8 of 20. IA number 8 is the application by BMRCL. my Lord.
Yes.
Our application was for 76 trees.
The 82 trees on.
No, our application was 76 trees. Cutting of 76 trees. Lordship, may can you take page 16, my Lord, of my application?
Paragraph 3. BMRCL sought permission for removal of 429 trees in phase 2 BMRCL project, which was granted.
No, that was the earlier case, my Lord. That was in the earlier case. Thereafter, my Lord, we made an application to change, because there's a change in alignment, to remove an additional 76 trees. That, my Lord, was then placed before the expert committee. The expert committee, my Lord, after examining it, said that 15 trees can be retained at site. Lord, may kindly come to page 10. Which has affidavit related with those. Page 4 has the details. Page 4. The schedule, my Lord, in page 4, which we've extracted the order here itself. Point 1, 15 trees which are listed with remarks. My Lord, got that? I'm sorry. In the application, my Lord, in our application file, the affidavit accompanying the application.
15 trees.
15 trees which are listed with remarks at LHS, RHS service roads and station area of phase 2B for constructing an elevated structure and 5 elevated metro stations which are listed with justification shall be retained on site.
One.
I'm so sorry.
Page 4. 15 are to be retained.
15 is retained. 6 may not have to be translocated. And my Lord, that leaves 55 trees on the next page. Here, my Lord, we are required to cut these trees and do compensatory afforestation. Compensatory afforestation, Lord, is for 610 trees. Not just the one which is cut, but is the ones which are translocated also. We are doing compensatory afforestation. So 610 trees, compensatory afforestation. 6 were not to be translocated, 55 to be removed.
Yes, this can also be granted.
That's two submissions, Manoj. Firstly, the compensatory plantation is sought to be done in Nedamangla Taluk, 45 kilometers away, outside the BBMP jurisdiction, in an area where the Tree Act has not even been, enacted. It's not even been made applicable to that area. I've produced with my statement of objections an order of this Honorable Court of 22/6/2021, which says obviously the compensatory plantation has to be within the city limits. It cannot be in a different part where the Tree Act is not even made applicable. That I have produced at page 11 of my statement of objections. 45 kilometers outside Bangalore. 45 kilometers from the location, and the location is outside Bangalore.
Page.
Page 11 of my statement of objections, my lords, is the
Some
order
order-
dated 22/6.
Page 11 is some order,
Yes, my lords. It's an order of this Honorable Court.
22/6.
Yes, my lords. And about 15 lines down, your lordships would see, as regards the official memorandum dated 23rd March 2021, which proposes translocation. Sorry. Set it as on. While the TEC does the same exercise, it must keep in mind principles laid down in subsection 5 of section 8 of the Act. It is obvious that translocation cannot be proposed at a place where the Act is not applicable. This exercise shall be undertaken by the TEC at the earliest.
TEC has specified the area.
They were specified the area.
They have
They
specified
located
as
an
Nedamangla,
area
man.
where not these trees can ultimately, we also have to ensure that there is space to put a large number of trees. And we simply can't plant trees where there's no space in Bangalore, for instance. And it is not a small number of trees. A large number of trees have to be planted, which is why I'm not in subsequent orders. Your lordships have permitted it to be done in the BMRDA area. Please see, my lord, the order dated.
No. Its order says that as far as possible.
As far as possible, my lord.
Then it says that where the trees are located today, it is not possible. At any nearby area, suitable place. It is ultimately for TSC to specify the.
Correct.
Where is that specific?
TSC has specified the location where it has to be planted as well. Please see, my lord, in the order itself, they have said so, and that has been.
Is at page 185 of their IA, my lords.
It's, my lord, we kindly see page 5 itself. We have identified, my lord, we've extracted the portion of. Transplantation.
Locations at Vasant, vacant space at KIITV, high-tech defense aerospace park.
180.
This is translocation.
That's translocation. 180. Sorry, which page? Sorry.
Which page is that? 185, right? 187.
187.
Yes, 187 is the location which we have pointed out.
88 is the plan.
Page 188, my lord, is the plan of, we've given a full plan, my lord, as to how the compensatory afforestation is to be done. Page 187 and 188.
Which paragraph?
My lord has 187, 5/12/24, our letter along with the plan.
Where?
187, my lord, is the entire plan for afforestation, which is there at 188 to 193.
Tell me how many of the saplings that you plant grow up to become trees? Any study has been conducted?
That's my very next point, that two things are supposed to be done by them. They're supposed to complete the plantation within 120 days. Thereafter, they have to submit quarterly reports. The quarterly reports they have not been submitting until we repeatedly pointed out to the
How many years?
court. from 2021.
Now, how many years they need to?
For 3 years. Now what they are doing, my lords, is they delay the plantation by 2 years. After the order is passed, instead of planting within 1 year, within 120 days, they plant after 2 years. And then I don't know whether this is deliberate or whether it feels like they are playing fraud on this court. That 3 years they count from the order of the court. After planting it for 2 years, they check on that tree, the sapling for 1 year, and then say 3 years are finished. Which is a blatant violation of not just the spirit, but the letter of the orders of this court.
Now, this is when AIDB's,
Yes,
compound.
it's within the KIDB area. At page 191.
Next AIDB is. Several industries. It's Bangalore. They're not in this. It's.
KDB means KDB acquired property or KDB office?
KIDB acquired property.
But industrial area.
Industrial areas.
Industrial area. Now,
Industrial.
once you give it for industries, what will happen to them?
No, not in the, of course, not the industrial areas which are there. Then there are open areas which are there, which not are utilized. So, for the, I don't know. The
Sanction plan is there.
yes, of course, Lord. The KIDB forms the layout.
Yeah.
And thereafter, Lord, alongside the roads.
Any agreement is entered into.
Yes, Lord, KIDB has permitted us. We've got, obtained permission from KIDB.
Now, tomorrow, they should not be removed for other purposes.
No, it can't. That not is our responsibility. It is our responsibility.
This act is not applicable there, man.
I think it is our responsibility to court, not the act.
Any agreement in this regard is
My Lord, agreement is not there, my Lord, but
KIAD.
If they cut it tomorrow, nobody will know, my lords, because the act
why
is not
will
even
we cut
applicable.
it tomorrow? Lord, this,
They are
these
cutting today.
expressions saying you're committing fraud, you're doing this, you're doing that. I mean,
I'll show the
it's
honorable
below
court.
my learned friend to make these statements.
Not
against the
bona fide.
Authority. We have, which is what I said even last time. It's not like we want to cut the trees. We have taken over a responsibility, which is a responsibility with the court. And your lordships, the directors, will comply with it. If there's some delay, my lord, I understand. As a public spirited citizen, my lord, the petitioner coming and saying this is not done. And then, my lord, we must do it. But it can't be, my lord, that they turn around and make allegations that you are a fraud, you are defrauding the court and all of this.
I'll show the
I don't
honorable
know
court
why
that
such statements are
Place in Bangalore, sir.
not- we have, Lord, now we've identified many locations. Several locations we've planted. We've even, my lord, in army space in Bangalore, we've planted there as well with the permission of the army. Lord, space is getting more and more limited. I need to go beyond Bangalore to plant. And wherever I plant, I should also ensure that it survives. Now, if I plant alongside the road, my lord, and it doesn't survive, then the whole purpose is defeated. My lord, please see page 204, my lord. The permission from KIDB is there. Page 204. Ultimately, my lord, our objective also is to ensure that Bangalore remains green. But if you say don't develop,
Public parks and all that.
yes, my lord, where, Lord,
See, if you can tie up with BBMP, we don't.
BBMP also we've done, my lord.
Of these portions of park area for places of worship, they can stall that and plant trees.
The park area.
In public parks.
Lord, please see page
See, in BBMP, we see this unauthorized place of worship cropping up,
2.
especially in parks and other places. So, public utility areas,
Yes,
if this can be done, probably green cover is more essential today in Bangalore than
Absolutely. I can't be
places
any,
of worship or
Lord, wherever it's
even
available.
Samudaya Bhavans, for that matter.
Yes.
Even Samudaya Bhavans. It's not required. Today, the fancy is to go outside the city and have functions. That has become the in thing. So probably no point in allocating lands for Samudaya Bhavans. Probably you'll have to take it with the government's.
Lord, wherever
And in
there's
the
space,
portions where
wherever there's
BMRCL,
space, my lord, we will put and plant trees. There's no difficulty.
So we'll ask the BBMP to identify the.
They can also, in addition, my lord, identify. I have no difficulty at all. Wherever there is,
If they make a request to BBMP, that can always be considered.
we've made.
lords, even the
BBMP
portions
is
which
done.
are already constructed by the BMRCL, they had felled the trees there to construct. On the roadside there, it can be replanted.
I don't know if it's place to replant on the roadside. Whatever, if there are constructive suggestions from my friend, we are happy to do it. No difficulty. But not destructive.
Destructive is only your side.
How many trees you will require to plant?
610.
10 times.
Yes, Lord. 61 trees, so 610.
No, it's from the orders of this honorable court in the last 4 years, 35,000 trees are not yet planted for 4 years. 35,000 trees.
Is the party?
BBMP is a party in this proceeding.
No, BBMP is not a party, my lord. The
Tree officer
is a
is,
party,
so
who is an officer of BBMP, my lord.
additional 33 trees left. 20,000.
But you're part of BBMP, right? Tree officer.
Yes, my lord.
You're part of BBMP.
I'm an officer of BBMP, yes.
Tender cancel.
Yes, my lord.
Probably with the vanishing green car of Bangalore, you need to set your priorities right, especially in allocation of your civic community site.
Yes, my lord.
See, certain areas have become garbage dumps. Instead of that, proper green cover can come over there. Places of worship in park areas and encroached areas, unauthorized constructions, they can be removed and these things can be accommodated.
Definitely, my lord.
And then even Samudaya bounds, I don't think they are required anymore within the city.
Yes, my lord.
I mean, you have to reprioritize. It's a policy matter. We cannot dictate the policy matter to you. But these aspects have to be gone into.
Speaking for BMRCL, my lord, whatever directions are given, or my lord, if BBMP wants us to work with them to find places to plant trees, we are happy to do it, my lord. There's no question. We have an obligation to not only the court, but also to environment, my lord, to protect it as much as possible. While I don't want development to stop, I don't think, my lord, the petitioners should have any grievance that we have some vested interest in cutting trees and
It is not a vested interest, my lords. But when this honorable court has passed direction saying in order to balance development and environment, we are permitting you to cut the trees, but there are requirements we are placing on you. For 3 years, they have been in violation. And they come before this honorable court and say, we will comply, but they do not comply. And then they come before this honorable court saying, my projects are delayed, but those projects are delayed by their own actions. They are in non-compliance of the statute. And what is worse, they are in non-compliance of their own undertakings to this honorable court. From 2021, they have been giving undertakings. Now, I have produced a memo. I filed a memo on this non-compliance showing that they made specific undertakings. Within 120 days, I will complete the compensatory plantation. Even that is not done. From 2022, orders are not complied with. And today they say, please believe me, we will comply with the orders. They have shown no intention to comply. In fact, on a recent decision of the Honorable Supreme Court, His Lordship Justice Oak in similar circumstances said you first do the compensatory plantation and then only cut a tree. Because this is what happens. They repeatedly come to this Honorable Court and say the orders are passed for the protection of the environment, but they're not complied. And I have never said they are in the business of cutting trees. No polluter is in the business of polluting. The laws are there to protect the environment from people who are doing their own business and destroying the environment in the meanwhile. May I hand over this? It's just a very short order. All we are seeking, and even more than the question about trees, I think this is more important, that when undertakings are given to court and this honorable court passes directions, those should be held seriously.
Applicant Bombay, applicant Bangalore Metro Rail Corporation Limited. By filing this application, seeks permission of the court to implement the order public official memorandum dated 5/12/24 of the tree officer and deputy conservator of forest, Brahad Bangalore Mahanagar Palike, Bengaluru, and to cut and to permit to, and consequently to permit to cut 61 trees. According to the applicant, the trees are required to be cut in view of the second phase implementation of the project where due to change of some alignment, the requirement arose to fell certain more trees. Full stop. Earlier, also the applicant had sought for permission of the court pursuant to the order of the tree officer for removal of 429 trees, which was granted by the court on conditions mentioned in the earlier order. Which is the earlier order? Earlier order passed. Full stop. The instant order dated 5/12/24 of the tree officer indicates that while the petitioner could be permitted to date it, order dated 3/9/24 in writ petition number in the 3/9/24 in IA number 6 of 24.
Yes.
3/9/20. Yes. Yeah. Then what did you write lastly? You- 5/12/24. As per the instant order dated 5/12/24 of the tree officer, the petitioner is permitted retain 15 trees at their continuation present location.
This is number 4.
66 trees are to be translocated, whereas 61 trees will have to be, will be permitted to be removed.
55.
Full stop.
55 to be removed.
55.
55 to be removed, 6 to be translocated.
55, not 61. Full stop. One of the condition to be observed by the applicants against the felling of 55 trees is that it should carry out the compensatory afforestation action by planting
610 trees.
10 more trees against each trees permitted to be removed. In other words, the applicant will have to plant about 550 trees.
610.
610 trees. Even for the translocated trees, we will compensate.
As prescribed. As part of afforestation. In lieu of the felling of the trees. Full stop. It transpires from the record. And it was highlighted, which was highlighted by learned advocate for the petitioner, Mr. So and so, that the BMRLC, Bangalore Metro Rail Limited, into the BMRLC has identified the location for planting of afforestation trees to be at Dobas Pet for space into Bricket, Aware Halli, Bricket over industrial area, Nela Mangala Taluka, Bangalore. It was submitted that this area where the trees will be planted as compensatory afforestation is 45 kilometers away from the territorial area of the BBMP. And also submitted that if
55 kilometers
from this location.
This departure is permitted and the applicant is allowed to plant the trees away from the, far away from the BBMP area, the city of Bangalore and the surrounding areas will suffer in terms of environment protection, and the tree cover will gradually vanish. Paragraph. As against this, learned senior advocate Mr. Dayan Chinnappa for the applicant submitted that no space is available where the afforestation plantation can be undertaken. He invited attention of the court to order dated 22/6/22/21, passed by the court in the present public interest proceeding only, wherein it is observed that the translocation and the afforestation should be done at the same site as far as possible. It is observed that where the trees are located presently, and it is observed that if the place is not available where the trees are presently located, the afforestation plantation may be done at nearby suitable space. It is however observed from a learned senior advocate Hart that it is ultimately for tree expert committee to specify the specific location where the trees should be translocated or replanted. It was submitted that the tree expert committee has already allowed the the aforesaid place for afforestation plantation. Full stop. The tree officer, though an officer under the Karnataka Felling of Trees Act 1976.
Reservation.
Is an officer of the BBMP also. The BBMP is party to the proceedings. In the totality of facts and circumstances, when the normal condition is that the afforestation plantation should be done at the same place or at the reserves of trees, Pura Namli. Done Kelly. At the same place where the trees are located, or at the best should be done within the territorial area of the BBMP. The court considers it appropriate to call upon the BBMP to find out and apprise the court whether it is possible to require the applicant to plant the fresh 610 trees anywhere within the territorial limit of the BBMP, yes, which may be the area of park or any open space where where the trees could be planted in compliance with the condition. Full stop. The court shall be full stop. The court is aware that the project in question is also for public good and public interest. Nevertheless, in order to ensure that the environmental balance does not get disturbed in the long run, the exercise of requiring the BBMP to find out the suitable place for afforestation plantation within the BBMP area is directed. Full stop. Learned advocate, Mr. Prashant, appears for BBMP, who will not only take instructions, but force the BBMP to undertake the exercise of surveying the areas to find out the feasibility of planting the afforestation trees in such area within the BBMP. The court may be apprised about the response of the BBMP in the above regard on the next date, put up on 20th, 19th of March, 19th of February.
That's one submission. Your lordships have recorded that the TEC has approved the location of aforestation. To my understanding, it is only looking at the translocation. It has not approved the afforestation. I'm subject to correction. I have request two more directions, my lord. I have pointed out that 35,000 trees pursuant to orders of this honorable court have not been complied with. The directions may be given time bound to comply with those also.
Which direction?
10 OMs have been passed since 2022, similar to this, where they have been directed to plant trees, they have undertaken to plant them. 35,000 trees are pending today where they have not planted. Over the last 4 years, no trees have been planted by them
Subject matter of this IA.
No, not this.
on their entire project, but similar OMs.
Will address later. Let this become.
Yes. Subject to that.
It's the same project, my lords. It's just a different reach, different OM.
To the issue,
So subject to this direction, any compensatory afforestation we have to do. It's only the location which has to be identified. Can we proceed subject to that plan? Because it's a, my lord, I will of course be able to afforest only in monsoon, which is, my lord, in June. Therefore, may I be permitted to proceed with the project, subject to, my lord, an undertaking that wherever it is identified, we will plant trees there.
Wait on 18th, we'll take a call.
18th, no?
19th. So we'll not grant further time. You do it. Find out, yes.
Deeply obliged, my lords.
Send your team or whatever.
Lord, afternoon or morning? The same list.
Second list. Afternoon, 2:30.
List one, cell number 7, Sharon Govindraj.
My lords, I appear for the complainant in this case, my lords.
For the accused, your lordship.
My lords, I pray 2 weeks' time, my lords, to file a counter affidavit in this case. Lords, I'm exercising 4 hours of visitation in a month. Now, my lords, by way of an affidavit, they want to reduce it to 2 hours. Then to that effect, they have filed an affidavit, my lords, to state the true and correct state of affairs, my lords. I require 2 weeks' time to file a counter affidavit, my lords.
That last affidavit.
Pardon me, lordship.
Affidavit is filed last time. Same.
Please, lordship. 13th it was filed.
Yes, same. time.
13th it was filed. Your
Every day you, regarding first week, second weekend, third week.
Please.
Please.
So what is the original direction? Every Saturday, Sunday?
Either Saturday or Sunday, my lords, I am permitted to exercise visitation for an hour in a mall, my lords.
Yes. So you're meeting every Saturday?
No, your lordship, it was not possible on multiple occasions because of inconvenience of both the parties. And there were health reasons and there was a bereavement in the family. Hence, it was not able to facilitate, your lordship.
Where is the order in the content?
Your lordship, the order was dated 10th of December 2024, which facilitated the visitation.
9/3/23?
My lord, first order was passed on 21st of October, where my lordship had interacted with a child and then passed an order. Subsequently, my lords, that order was continued, my lords, by way of order dated 6th of December and 10th of December.
You argue physically better so that we are better.
Yes, ma'am.
assisted.
Weeks time.
Yes.
2 weeks time.
21st.
Grateful.
My lords, 28th, my lords.
28.
Grateful. Grateful.
So PL matter, seal number 8. Mr. Ravi Shankar.
In this matter, my lordship, respondent is running a quarry and mining business in survey number 49/1 and 49/2 and survey number 55 situated at Kolgatta village, Kasba Obli, Turvekere Taluk, Tumkur district. My lordship, here the running the quarry business in the said vicinity of the Kolgatta village, which caused the detrimental to the health of the human being, farmer's crop and fodder's crop and cattle, the releasing of the dust and releasing of the
Now you are filing the petition on behalf of Gram Panchayat.
Gram Panchayat.
Where is the resolution enabling you to file the? You are a member and you are projecting yourself on behalf of the entire Panchayat.
Panchayat.
So where is the resolution of Panchayat entitling you to file the petition, authorizing you?
They have passed the regulation and they have authorized the member,
Let us see, where is that?
member to file the
Where is that?
annexure WW, my lordship, page 436.
436.
My lordship.
No, there must be a resolution of the Panchayat, general body of the Panchayat, not by the president. If you are
The president has authorized him
If you are
to.
projecting the Panchayat as a petitioner, there must be a resolution of the Panchayat.
They have passed the resolution, my lordship. I have not furnished in this.
Get
petition.
it,
I'll furnish the.
27th. The petition, which is in the name and style of public interest litigation, is filed by the Gram Panchayat through a member who projects himself to be on behalf of entire Gram Panchayat. Full stop. What figures on record paragraph is the letter of authorization issued by the president, which may not may not suffice in law when the petition is in the name of Gram Panchayat. Full stop. The petitioner may produce the resolution of Gram Panchayat authorizing the petitioner to file the petition in the name of Gram Panchayat and pursue the cause. Full stop. Unless this requirement is, unless the court is satisfied about the above aspect, no question arises to go into the merit part of the petition. Learned advocate of the petitioner, Mr. So prays for time, stand over to 27th of February.
Number 9, Tilak Raj SP.
Lords, I appear for the petitioner in the matter.
Please, Milords. I open my audible minutes. I appear for the petition on the matter. This is a petition that challenges the notification of the 26th of January 2024, wherein the rank of cabinet ministers has been extended to certain members of the Legislative Assembly in violation of Articles 164(1)(a) of the Constitution. If I could request my lords to come to the translated copy of the notification, which is at page number 50, and my lords could see the preamble over the table, which contains the impugned portion specifically. Does my lords have it? It says, in pursuance of the Honorable Chief Minister's proceedings dated 26th of January 2024, the following honorable members of the Legislative Assembly have been appointed with immediate effect as chairpersons for the boards and corporations shown against their names, with the rank of cabinet ministers, with all facilities provided to ministers of cabinet rank for a period of 2 years. So we do not have a problem with them being appointed to these positions. Our issue is with respect to the extension of cabinet rank to their positions, because under Article 164(1)(a), the ceiling is only 15% of the total number of members of the Legislative Assembly who can be given cabinet rank, which in the context of the state of Karnataka is 33.6, translating to 34. There are already 33 members in the cabinet, and we have annexed that as well for my lord's consumption. Now, with this, 34 members have been additionally added who have been given cabinet rank. This is in serious violation. Therefore, my lords, on the facts of this case, the limited issue is, can such people be extended the position of cabinet rank along with the facilities and perquisites which are available to a cabinet minister? Is this in compliance of 164(1)(a)? Can I request my lords to kindly consider looking at Article 164 for a moment? I'll read that, and then I'll show the provisions of Article 191 as well, under which certain offices of profit have been exempted from disqualification.
Wait
My
a minute.
apologies. Please, please. My apologies. My sincere apologies for the ambient noise. I happen to be sitting in the presence of the Supreme Court.
91 what? You are relying on?
164.
That's 164, which is other provisions as to ministers. And 164, 1 capital A, if my lords has it, may I read this for the court's consumption? Yes, 164, 1A, 1 capital A. Does my lords have the provision?
164.
Yes.
The total number of ministers, including the chief minister, in the council of ministers in a state shall not exceed 15% of the total number of members of the legislative assembly of the state. And if my lords were to take a look at the extract from the official website of the Karnataka government, as on date, there are 33 ministers already, which is the permissible number is 34 out of the strength of the assembly. Now, with this additional notification, which is the impugned notification, 34 members. Please.
34 are, what is the figure?
The existing figure is 33 of
33,
members.
33 cabinet,
members of,
33
yes, 33
cabinet.
Yes, the ceiling is 34. Permissible number is 34 for the state of Karnataka, going by 164.
34 are cabinet rank ministers presently working.
33. 33.
33.
Yes.
And the
34
permissible,
is permitted.
1 second,
34.
1 second.
Yes.
And permissible limit is 34.
Correct.
That is 10% of the
15.
15%.
15%. Yes. Now,
under the impugned notification, if my lords were to come to the impugned notification, 34 members have been added additionally with cabinet rank.
by virtue of giving them posting,
Yes.
appointing
Not
them.
just the posting. So if they were appointed as chairpersons for boards and corporations alone, that is not problematic because that is permissible under Article 191.
All facilities
The
are
issue,
available to cabinet.
exactly, with rank of cabinet ministers and with the facilities of cabinet rank, this goes against the mandate of 164(1)(a). Open 164(1)(a) and 191. First 164(1)(a), because I see open it from the article itself. Yeah.
So these 34 appointments are by one stroke of pen, by one notification?
Unmute button.
Please, Manoj, yes. Can I just request the honorable control room to not mute me? I'm sorry, it just so happens that there is a ambient noise, I understand. So 34 people here have been additionally added. So the first thing is their appointment to these offices, which may be perhaps exempt under 191, which speaks of the state having the power to appoint such people under a specific legislation, which prevents them from disqualification for holding offices of profit. But when you extend the cabinet rank, then you've gone from 191 into 164 1A prohibition directly.
Pardon?
So if the notification had been limited exclusively to appointment to these boards as chairpersons, there would have been no problem at all, because that is provided for under Article 191. But when they're extended the position of a cabinet rank, then it is in the teeth of
you're arguing from outside the Bangalore?
No,
Your
Millards,
voice is not.
I'm in the Supreme Court. My apologies, I'm in the Supreme Court. Millards.
Your voice is not properly reaching. Yes.
I'll just make the argument better, Millards. My sincere apologies. Am I audible better now, Millards?
Yes. Audible, yes, but yes.
The point,
please proceed. Yes.
please, my sincere. The point is, their appointments to these positions as chairpersons of boards in themselves is not problematic, because that they are allowed to do so under Article 191. I know.
You are welcome to argue, but we are thinking that such an important point you are raising and you are arguing from the compound of the.
Millards, my sincere apologies. It just so happens that I was briefed last night. If my lords could perhaps give me a short date, I'll come back and I'll have the privilege of appearing before my lords in person. I'm happy to do so. I'm not near the Karnataka High Court.
18th?
Can I just confer with my court clerk for just 10 seconds, please? Just 10 seconds.
Yes.
Just a second. Could my lords consider giving me the date of 21st of February subject to my lords' convenience? 21st.
21st. All right, 21st.
I'm so grateful, so deeply appreciated.
Idea is not to criticize you or prevent you, but we can.
No, I understand.
That's
I understand.
So welcome.
I'm so grateful for the kind indulgence. Grateful.
21st.
This is number 10. To Venkatesh P. Dalwai.
Millards, I appear for petitioner. Millards, this is a PIL by the High Court Legal Aid Services Committee, Millards, with reference to parks and open spaces, which my lord heard the last occasion.
It was heard and kept for infect test.
Yes, ma'am. Grateful.
Replies are filed by.
Yes, readings are come. I filed an affidavit before the court. I appear for BDA.
There is an amended petition, Millards, which is filed on 6th of July 2021.
Twenty-seventh, we'll take a call. Let him go. Not read. What is that? Twenty-seventh at 2:30.
Grateful.
Green bench matter, still number 40, still number 11.
Lords, this is a matter with respect to solid waste.
Yes.
It's a matter with respect to the deserted area of Kaikini village forest where solid waste is being disposed, collected from Murdeshwara area, my lord.
So both the authorities, this Panchayat and Forest,
My lords,
are of the same opinion.
my lords, kindly permit me to take your lordships through the petition, my lord. So Marakali Mumatil Musallamin is an organization in Kaikini village, which is under Murdeshwara, which gives a contract to the petitioners to lift the waste from the Kaikini village market. And the same was being dumped in the area that we have mentioned under survey number 569, my lord, which is a deserted forest land. And primary problem here is that both respondent number 1 and 6, which is the Panchayat and the range forest officer, they have written letters, and the endorsement which are issued is with respect to 559.
You have a contract with certain municipality or what to lift the wastage?
No, my lord, this Marakali Mumatil organization is the one which has given us the contract to.
Who has given you the contract?
Marakali Mumatil Musalamin, which is an organization in the market area of Kaikini village, my lord.
Now, how can you dump it in a forest area like that? If you want, you can treat it. But you can't be permitted to dump like that. It will affect, and who is that organization to grant you any right?
My lord, that's what we, previously there was a writ petition which was filed and direction was issued. Lord, kindly permit me to.
You are saying that number 5 have granted you the permission to dump.
Yes, my lord. Respondent.
Markazi Jamaatul Muslimin Murdeshwar. What is that dargah?
My lord, it's an organization which has a market area control in.
So you collect the market waste, go and dump it in a forest so that forest gets destroyed, is it? And the wild animals and the people are put to loss. You are, and in Western Ghats, and you want the seal of this court to do it.
My lords, previously when we had filed a petition before this honorable bench, there was a direction issued, particularly directing the respondents to consider the representation and make all the accommodation to dispose of the solid waste, my lord. This is a deserted forest land what we are speaking about, and it is only about the degradable waste we are speaking, because there is no other option.
Whatever waste has to be treated.
My lord, we are ready.
Unless you can treat the waste, or there is an area earmarked for dumping the waste by the authorities concerned, you can't be permitted to go and dump it over there.
Lord, the specific direction we might ask in this case is kindly grant the Gram Panchayat, which is under the obligation to provide a place for us to at least set up a plant or any form of disposal.
They are not
activity that
under
we
any
achieve.
obligation.
My Lord,
What right you have got?
You are a contractor and collecting the garbage.
And belonging to a private person, and you are authorized by a private entity.
My Lord, since 2021, there has been an issue and most of the days this solid waste is rotting in the market itself, my Lord. This is Murudeshwara we are speaking about is the travel, a tourist area also.
There are city municipal councils and town panchayats to cater to these needs. And they have to dispose of the waste in a scientific manner.
Yes, my Lord.
Award contract for that particular purpose. And not a religious organization who authorize you to collect the waste in the market yard and dump it in a forest place so that flora and fauna as well as the wildlife is threatened.
My Lord, kindly see annexure C, the photographs that we have produced, my Lord. That is the area we are discussing about.
You are enforcing what kind of right in this?
Lord, waste is being generated in a market area.
It is your right to question the refusal to dump in a much less a right, there is on the contrary corresponding duty not to do that, not to do that. What do you inviting order?
My Lord.
You are inviting order.
Lord, any direction which could help us find a suitable place through the Gram Panchayat at least to dispose of the waste is our prayer, my Lord.
In fact, we are not inclined to grant even permission to pursue. Invoking the jurisdiction of this court under Article 226 of the Constitution. Two petitioners have filed this petition, seeking to get set aside two orders. First order is passed by, first order is dated 25/8/21, passed by the Gram Panchayat, Panchayat Development Officer, Village Panchayat, Kaikini, Patkala Taluk. The second order is dated 1/9/21, which is passed by the Zonal Forest Officer, Patkala. Both the orders reject the request of the petitioners to permit them to dispose of the garbage waste within the Gram Panchayat area or within the forest area, as the case may be. The request of the petitioners is rejected on the ground that the action on part of the petitioners is prone to cause damage to the environment, and that the garbage cannot be permitted to be dumped in the forest area or within the Gram Panchayat area, which is being done without any justification and authorization. Paragraph. The case sought to be put forward by the petitioners is that risk number 5, which again a private entity in the name and style of Markazi is again an entity, the name of Markazi Jamaatul Muslimin MUSLI MWN Murudeswar Dargah Road, Murudeswar at Murudeswar has granted permission to the petitioners by passing resolution dated 10/1/21 to lift the wastage in the area of Kaikini village, to keep the area clean and dispose of the garbage. Is the say of the petitioner that since the date of such permission granted by respondent 5, the petitioners were dumping the garbage in survey number 569 of forest area situated at Kaikini village, Mawali, Hobli. The petitioners have audaciously averred that since several years, the wastage was being dumped in the said forest area. It is the case that since they are prevented from doing so, they have no place to dump the garbage to carry out the resolution of number 5, and therefore they approached the Gram Panchayat authorities and the forest authorities with representation, which were turned down as per the impugned, as per the decisions reflected in the impugned communications. Full stop. The petition is filed and the prayers are advanced in the background of peculiar facts where it is the claim of the petitioner that the entity, respondent number 5, has asked by resolution, asked the petitioners by resolution to dispose of the garbage waste, and that in that light the petitioners should be permitted to dispose of the garbage in the land survey number 569 at where they have been doing the disposal of the garbage since several years. Full stop. There is total dearth, ERTH paragraph. There is a total dearth of merits in the case of the petitioner. Full stop. The petitioners seek to enforce some obligation which is stated to have been cast on them by respondent 5 by passing a resolution regarding disposal of garbage. Admittedly, the garbage which is sought to be, the land which is sought to be used for garbage disposal is a forest land. In any view of the matter, it is incomprehensible as to what kind of right, and as such what right the petitioners are seeking to enforce by filing this petition. The petitioners do not have any right to seek such relief, nor they have right to get their case considered, which is totally meritless and strange in itself. The petition is summarily dismissed with cost of rupees.
Number 12, to Mohammed Rizwan Ahmad.
Appear for petition. Lord, appear for the respondents, Lord.
I request for 4 weeks' time to file my statement of objections.
Notice
There's
is
certain
issued.
facts which I would like to
Notice
bring
is
it.
issued.
Sorry,
Notice is issued.
yes. notice
Yes,
has
on the
been
last
issued in this
occasion,
case.
having regard to the urgency, my lords were pleased to direct him to respond today. It is, my lord, a short date, my lord, instead of 4 weeks,
When we will
I
file
need
the-
to,
Because this is,
middle of,
well, first week of March, my lord, I'll file my.
no,
I'll
can
receive
it
the
be
entire
27th or so, my lord?
27th. 3rd March,
3rd March, yes.
3rd.
Not 3rd, my lord. Second March or so.
2nd is.
4th, my lord.
Fourth. You
I'll
file
file my objections by.
Can I request for finally, my lord? Because the problem is I have spent 858 crores. I am a central PSU. MOE have granted me clearance. State is not executing me a lease on account of, if I am permitted to say so, some political ego clash.
Learned additional High Court General.
Kiran Ron.
Kiran Rons takes time to file reply. Full stop. In view of the urgency which is sought to be demonstrated by learned senior DL and Rao, the reply shall be invariably filed on or before 28th of February. The matter, the petition may be listed on 4th of March.
Great.
Great.
Copy of the reply shall be served on the petition.
Yes.
13 is urgent. Number 14, Sandeep Larry.
Writ petition, my lord, seeking a writ of mandamus. Consider our representation at Annexure A, my lords. In brief, our request is this, that from 1991 up to 2010, without any problem, my lords, we were conducting mining lease activity for extraction of China clay, my lords. Now, after that, my lords, all of a sudden, this issue of deemed forest appears. In fact, there is a report of the DC also, which we have filed along with our writ petition, wherein after a spot inspection, it's found that there are no trees whatsoever. So all we're asking, my lords, is to consider our representation. We've moved our unit because, my lords, this area is rich in China clay. Let them consider it, my lords. My learned friend could get instructions. If my lords could have it at the earliest date. My learned friend could get instructions on the status of my representation annexure A. What the state, in fact, the state also doesn't appear to have a serious problem with the petitioner, because the deputy commissioner himself has recommended that this be deleted from this list of deemed forest. So we just want to know what the status of that is. And if it is deleted, at least I'll be able to operate for the remainder of my lease period. The state itself, my lords, from 1991 up to 2020 has permitted me to conduct mining lease with a small break.
Please see annexure A, my lord, though it is.
We'll see, but this deemed forest.
My lord, we have written to the Supreme Court, my lord, requesting that certain areas be considered as deemed forest. So far, we have not received any response. My lord, may please take annexure A, though it is dated 27 November 2024. My lord, it is received in the office on 28/1/20. I'm sorry, I read it wrong, my lord.
It must be
Annexure A.
2811.
2811, I think. Oh, it looks like 0.
It is 11.
No, representation, this is 27/12.
No, 11.
No, 2711.
11.
Is the representation.
But in the prayer, it says 27/12. That's why I read it wrong.
It must be a typo. I'm sorry, it's 2711.
Find out.
Lord, we'll consider it in accordance with law.
Yeah.
My Lord may grant us some time, because that is what their prayer is.
Very well.
But your renewal period is in currency or it is already expired?
As per the amended law, Maharaj, the extension is for another 20 years. From 20 to 2040, I'm eligible, provided this issue is cleared. So initially, it was 1991 up to 2010, then a 10-year extension. Now I'm eligible for another 20-year extension.
In your rule, section 8A.
Yes,
Rule.
under the
My lord.
Rule.
Rule. KMMCR.
no, it won't be KMMCR. This will be under the
MMDR,
main
I'm
act,
sorry, my lord.
because this is a major mineral. Minor minerals are covered under the KMMCR. This will be under the because of course, my learned friend is right. The KMMCR was brought in line with the amendment to the central statute. Could my lords kindly see page 132 and 133, my lords? That may clarify any doubts your lordships may have. Where the state government itself, page 132, which is a communication by the deputy commissioner, my lords, to the additional chief secretary. It says deputy chief secretary, but it should be additional chief secretary of forests. Kindly see at page 133. We are only concerned with these 4 hectares, note, second paragraph. But the 4 hectare in serial survey numbers 26 and 27 of so-and-so village, China mine has leased, it was personally inspected by the Tahsildar so-and-so Taluk on 21/10/2017. It was found that no trees have grown in the said area. Instead, the Tahsildar has submitted a report as per reference to that Murdeshwar Ceramics Bangalore has been found to be mining and deemed forest proposal may be dropped. Therefore, the 4 hectare land leased for China mine in survey number so-and-so has been requested to drop the proposal previously submitted to deemed forest.
Vikram, you read with page 136.
132.
130.
The translated.
The petitioner, which is a company engaged in the manufacturing of vitrified tiles, by invoking the jurisdiction of this court under Article 226 of the Constitution, desperate to direct whisper number 4. The additional chief secretary forest from Ecology and Environment Department, Government of Karnataka, to consider the representative notification dated 27/11/2024 and to consequentially delete entry at serial number 3347 and 3348 in relation to survey number 26 and survey number 27, being the land at Maddenahalli village, Bashe, Halli, Pobli, Sidlagatha, SIDLA, GSA, TA, Taluka, Chikaballapura district, at measuring 4 acres. 4 hectares, integrate 9.88 acres.
4 hectares means 4 hectares.
Acres, 9.88 acres.
Correct, 9, correct.
From the purview of the deemed forest. As would be pointed out by learned prayer, we need advocate. Not only the prayer is limited in its nature, as above. As would be pointed out by learned advocate, as would be highlighted by learned senior advocate Mr. Vikram, assisted by learned advocate so-and-so, that the controversy, that the dispute in the background also lies in narrow compass. It is the case of the petitioner that the petitioner obtained mining license in the said land in question on 12/8/1992, which was initially for a period of 12 years from 19/3/1991 to 18/3/2011. First of the competent authorities received the no objection and clearance certificates, and subsequently upon Karnataka State Pollution Control Board also issued consent for establishment of mining operations. The mining lease was renewed on 31/5/17 up to 31/3/20. It is the case of the petitioner that by virtue of the amendment in the minor mineral concession rules, the petitioner is now entitled to get its lease renewed for further period of 50 years.
For further period of 20 years,
Further
overall
period-
it'd be 50 years.
Further period 20 years. It is the case of the petitioner that the petitioner was allowed to execute the renewed mining lease and operate the mining and continue the mining operations as per all mining operations. Full stop. When a renewed mining lease was also entered into in favor of the petitioner on 13/8/18 by the Director of Mines and Geology. Full stop. Thereafter, an application was made by the petitioner on 11/4/23 to the Director, Department of Mines, to renew and extend the mining lease of the petitioners for 20 years. However, the said request was
Kept pending.
kept pending.
Request for extension is not yet granted.
Kept pending and the extension is not granted. It is the case of the petitioner paragraph that despite passage of 7 years and more, from the respondent authorities have set tight on the ground that the entry in the revenue record mentions the lands in question to be in deemed forest list. It is in that light, it is in the above light, it was submitted that the prayer, that the representation was made. It is now prayed before this court to direct the respondent court to decide the representation. Whereas learned additional advocate, government advocate, Srimati Nilofer Akbar submitted that looking to the kind and nature of the prayer, which is only to require the competent authority to look into the representation and decide the same, the same could be considered. In light of above, this petition is disposed of by directing the court to consider and decide representation of the petition dated 27/11/4 in relation to the aspect whether the prayer numbers 26 and 27, where the petitioner is claiming the leasehold rights, are the areas within the deemed forest. Full stop. The competent authorities shall undertake the exercise, record factual finding and intimate the decision to the petitioner in accordance with law within a period of 8 fixed months. Full stop. It is clarified that this court has not entered into nor has expressed any opinion on the merits of the case of the either side.
Grateful.
The petition is disposed of, granting above limited direction.
Grateful. This
Lord, as on date, they do not have a quarrying license. They have sought for, my lord, renewal.
8 of piece of certified copy of this order.
My lord, as on date, they don't have a license. My lord, the license period has come to an end. They have sought for a renewal, saying that now it can be granted
Not
because
carrying
of,
out operation.
Absolutely.
That will correct. it.
Absolutely.
from the last 7 years, they haven't been operating.
Not on this case, my lord, since the issue of deemed forest, I just thought I'll bring it to my lord's attention. Any other case, there's a judgment of a coordinate bench, my lords, dated 12th of June 2019, which may throw some lights. Of course, not on, this is a very simple case, my lords, where a coordinate bench has exactly defined what is a deemed forest. In fact, there is a finding that the concept of deemed forest is alien to law. There is no law that defines what is deemed forest. It records the submission of that there's a list submitted before the Honorable Supreme Court, possibly for other cases, and not for this case. But since your lordship brought up that issue,
At least we had an examine to.
WP 54476.
Occasion to look into the issue.
Yesterday, my lord, and I had made,
Earlier.
No, I'll hand over a copy to my learned friend also. It may throw because in other issues. Because what the honorable bench has held in that case is, in this case is
They have submitted some report and
list.
Yes, and
the-
yesterday, my lord,
it was accepted by the Supreme Court.
it's
the-
pending before the Supreme Court. We are requesting that those areas be declared as deemed forest.
Correct.
And yesterday that notification was produced in another writ petition, my lord.
In fact, what the bench has held is this, all of the genesis starts with Godavarma's judgment of, I think, 12th of December, 1996, where a list was supposed to be given. But they've defined forest to mean any forest. It could be a private forest, notified forest, non-notified forest. So in light of that, Manoj, what the bench has held is in each and every case, you must apply your mind. Are there trees growing over there? Is there actually a forest over there? And merely drawing up a list may not be... I'll just hand it over to my learned friend.
The notification is
Grateful.
obliged.
Writ appeal matters. Seal number 15, Mr. K. Krishna.
For the appellant in 891 months. This is the case where, my lords, your lordships may recollect, an undertaking was given before the learned single judge that possession would be handed over if the package compensation is handed over to the writ petitioners. Now, before your lordship, they said the package compensation is not sufficient. Please look into what was awarded to the neighboring land and so on, my lords. I think on 31st January, my lords, they have, I'm sorry, 30th January, I'm told, my lords, that BMRCL received a letter requesting that compensation be paid either at the rate given to the adjacent owners or at the prevalent market rate in 2020. So we're just examining that. If your lordships could kindly give us some time, we'll just examine what can, because the neighboring landowner is one Shanta Industries, where on preliminary instructions, they stand on slightly different footing, but we'll look into that. On 30th January, we received this letter.
I appeal for respond number 125, landowners.
So petitioner may put a proposal.
Yes, that's what the lordship said. They've posted a proposal. Now we're just considering it.
My lord, other order last time passed, my lord, 24/1/2025. The respondent shall make available to the court the amount which is payable under the package compensation as well as the amount which is paid to the adjoining owner, my lord. That proposal is not yet given by the BMRCL. That proposals, what the amount paid to the adjoining owners, they have not given any proposals. And package compensation also not given any proposals.
That's what I said, Malas. That what they've now proposed is either you give me the 2020 rate or the neighboring landowner. That is under consideration. We look into that, Malas. We look into what the neighboring landowner has received.
Kindly taken up
If
on
they are on the
21st,
same.
my lord. 21st of this month. 21st of this month, my lord.
It's too early.
Sometime in March, Malas, could your lordships consider.
It was stated by learned counsels that proposal which was referred to in earlier order dated 24/1/25 to be submitted by the petitioners regarding package compensation or payment of compensation.
Yeah.
Based on the adjoining, based on the consideration of the amount paid to the adjoining owner would be looked into. And is being looked into. Full stop. In that view, stand over to 26th of March.
16 is urgent. Seal number 17, to Monesh Kumar KB.
Seek for accommodation, please, my lords. Senior counsel with appears has gone to Prayagraj today, anytime after next week, my lords.
Who has gone to Prayagraj?
Senior counsel, Mr. Raghavan. I'll only request, my lords, sometime next week or week after next. My lords, this case, please, my lords, pertains to a valuable piece of state lands, please, my lords, on Cunningham Road.
All right. Learned senior counsel, Mr.
Raghavan, Mr. Raghavan.
Stand over.
Sorry, my lords,
You are senior enough. Why do you say that, Prayaga?
I'm sorry, my lords, it's
You can say that some personal engagement. or something.
only for today, my lords, may I request, my lord?
You can also say the religious engagement. All right. At the request of learned advocate, Mr. So-and-so for the appellant, send out. When shall we?
Any time after next week.
A note shall be filed in the registry.
Please.
Stating that the council has returned from prior. Soon after the notice filed, the matter shall be listed.
Notice, my lords, to others.
No, stand as per the, no, don't write that. As per the request of learned advocate, Mr. So-and-so appellant, stand out. We'll keep it on 23rd, 25th March.
Please. So,
Number 18. State appeal.
18 is state appeal, my lord. There's a delay, my lord, in the filing of the appeal. There's a delay in filing of the appeal. I shall take out notice, my lord.
Notice written.
The connected writ appeals also on the.
27th March.
Please.
Number 19. Madhukar Deshpande.
Notice.
The serial number 19 and 20, my lord. Other than these two, there are other 4 matters, my lord. There are totally 6 appeals, my lord, challenging the same impugned order, my lord. My lord, I'll give the number, my lord. All the 6 matters may kindly be listed at once, my lord. Because
But
there is a
here
delay.
we may issue notice in this delay condonation.
Once the matter may kindly be heard and delay. Other 4 matters are there, my lord.
Notice returnable 19 and 20, returnable on 24th of March. It was stated by learned advocate paragraph, Miss so-and-so, what is name?
My lord,
That,
Maheshwari.
Other 2 writ appeals number,
Other 4 appeal numbers have
other
given.
4 writ appeals.
I've given.
Number so-and-so are cognate appeals to be listed, required to be listed along with the said appeals. Full stop. Since in the present appeals, the notice in the delay condonation application, in that also there is delay?
Please, my lord, 317 days delay
In
all
all,
6
in all.
appeals.
The delay condonation notice is issued in the present matters, comma, it is directed that the registry shall list the cognate, aforesaid cognate appeals today itself by preparing a separate board, full stop. In all the 6 appeals, there shall be notice in delay condonation application, returnable on 24th.
Number 21. Mr. Vikram Balaji.
Question, my lord, involved in this case. Even after the expiry of the non-alienation period in the terms of the grant, but after 1179, section 4 to contemplate the prior permission is required. Now the learned single judge, the grant was in 1931. It was sold in 53 with a condition of reconveyance. 10/10/74, it was purchased back. Where is the reconveyance? As on 1179 minutes, it was a granted land. In fact, I placed on record the 2 division bench judgments where the word granted land has been interpreted with all liberals. Because the word section 4(2) says any granted land, the word any has been interpreted with a liberal construction. No person shall after the commencement of this act transfer or any acquire any granted land without the previous permission. Now it was sold, my lord, in the year 1992 without the permission of the government under 4(2). The learned single judge said it has been non-alienation period is over. Therefore, it becomes the personal property of the owner. But this question has been considered in 2 division bench judgments.
Which are the judgments?
Pardon, my lord.
Which are the judgments you are to?
My lord, along with the memo I filed. On 4th January 2025. I
Because
filed.
what does the judgment say? Now, this conveyance was in by.
My lord, the short question would be, any land after the act came into effect, if it is a granted land, at least once there should be a permission. Otherwise, my lord, the act would applies. It will be in a direct contravention of section 4(2). In fact, page 11, I'll just read it. So far as the first ground raised by the petitioner is concerned,
Now
it
the
is
view
quite
that-
clear.
The view is that after laches or long delay, can't fall back upon the aspect that section 4(2) was breached. So in that sense, in the context of the long passage of time, in taking action under the act, the sanctity and the effectivity of section 4
It is, but
is at least diluted, if not taken away.
not by consent, the statutory ground cannot be waived. 4(2) means it is void, means it's void.
Notice written.
I had the benefit of an entry model.
Notice returnable on
Status quo regarding the nature of the property that,
early will give. Early than other matter, 5th of March.
please.
Number 22,
Please,
Mr. Gautam, LC Bulldog.
wait, please.
Delay of 18 days,
There is a short delay of 15.
returnable on notice.
Meanwhile, my lord, one humble request.
14th March.
One humble request, let them not precipitate, my lords. What is the order under challenge is this, my lords. A person was, my lord, contesting respondent was facing disciplinary proceedings of serious charges found guilty, my lords. Therefore, the transfer order which was issued to him was rescinded within 15 days, my, within the period. Now what the learned single judge holds, my lords, transfer order cannot be rescinded without notice to him, my lords. On that count, my lords, the order has been held to be bad, and I am sort of displaced. I am continuing there. And my lord, as for the interference in service matters of this nature, my lord, disciplinary proceedings.
Until the delay is gone down, the court does not have the jurisdiction to deal with it.
I do go down, my lord, but having got the special circumstances, but now they want to take charge, my lords, and his conduct also, my lords, where there are serious charges held guilty in the disciplinary proceedings. Therefore, my lord, initial transfer order was made conditional, my lords.
Will set aside the action of your right ultimately. At this stage.
I bow down, my lord. Till then, my lord, if he comes and nay,
What we can't.
and his
grant-
conduct also, my lord, please.
What we can't grant, we don't grant.
Please, my lord, that's, your lords, may the delay is only this much, my lord, 17 days, my lords.
14th March.
In the meanwhile, my lord, there is one more matter, my lords, in the same case, my lords. It's in the arising out of the same judgment, my lords. There are two. One is order of transfer, one rescinding the transfer. He also filed one more writ petition to give direction to the authorities to post him to the same place, my lords. That is the writ appeal number 67, my lords. That stands posted to 23rd, my lords. This may
67 or 25
67
of
of 2025, my lords.
It is coming upon
To 23rd is the date fixed, my lords.
23rd of this month.
This month, my lords. Both
23rd
arise out of the same, my
23rd
lords.
is Sunday.
Then yesterday.
Yesterday only.
It was yesterday. It was yesterday, my lords, at the
27th. It will come on 24th, 20, 27th.
27th.
So this may also go to 27th.
Please, I would rather pray for an early date, so otherwise it's not rendered infectious, my lords.
Because of other matter, we have given 27th.
Please.
So then.
We will ask to kindly permit us to serve on the council appearing before before the single digit.
In addition to normal mode of service, former learned advocate for the appellant is permitted to serve the counsel who appeared on behalf of the respondent before learned assembly.
Please, please. Grateful.
Case number 23, to Madhukaran respondent.
Lord, I'm arranging an interim order granted by the learned single judge, my lord. The learned single judge has directed us to allow the students to appear for the 10th exams of the CBSE, my lord. And it is scheduled for tomorrow, my lord. The exams are scheduled for tomorrow. My only
Subject to final outcome.
My lord,
My lord, this will not survive. Yesterday itself, admission cards are issued to the students, my lord. Now they are challenging the order. It will not survive for consideration, my lord. They themselves.
I will comply with that officer objection. I undertake to comply with that officer objection. There is a other today we have paid the court fee. Already we have paid. There are other issues involved, my lord. They have studied for 9 years, first standard to 9th standard in the state syllabus, my lord, with the state board. Our affiliation rules, when they admitted, we made it very clear to them that they cannot appear for the 10th exams. Only from the year 2026, the students of that particular school can appear for the CBSE. But they have sought for the interim prayer for a direction, and there is an interim order. And for that reason, I am challenging that order. My only endeavor is that, my lord, if they appear in our examination, if their result is not declared, my lord, they will not be in a position to appear for the state board exams also. The state board exams are from 1 month from today, my lord. It is scheduled on 21st March 2025, my lord. And for that reason, I am also seeking for implement of state board. And now my learned friend informed me that hall ticket has been issued. The reason is that, my lord, contempt proceeding also has been initiated against the board, my lord. Under the threat of contempt, my lord, we have issued the hall ticket. If my lords permit me, I request my lords to kindly take Annexure D, page number 33, my lord. That is the certificate of affiliation which we have issued on 25th February 2024. There is one particular table, my lord. The last middle portion table, last portion, my lord. It reads like this: year and month in which first batch of class 10 will appear in board examination. That is 1st April 2026. Now, by virtue of the direction, my lord, we need to allow them, even though they have not studied or they have not been recognized as student of our school, our board.
The order which is not to be called in question. The filing this writ appeal is dated 27 January 2025. Passed by learned single judge in the pending proceedings of the writ petition. Order reads as under the order. Evidently, paragraph after quoting, the order is interim order, whereby evidently the order is interim order, whereby the students are permitted to sit in the 10th standard examination for the academic year 24-25. The examination is scheduled to start from 15 to 2025. Learned advocate Mr. So-and-so would submit that even the
Already issued admission cards yesterday.
admittance card
Other school students to take up the examination this year.
Now listen, mister, when did you get the affiliation to
That's February 2024 itself, my lords.
February?
February 2024. We made request before the authority on March 2024 requesting preponement of the affiliation, my lords.
Okay. Before getting affiliation from CBSE, you are not supposed to admit students for CBSE course.
We have not admitted any single fresh student to the 10th standard, my lords. All the students were shift over category, my lords. Earlier they were in the state board, and then after
How can you do it?
my lords, after affiliation only, the existing students from 9th standard, they'll
See, the syllabus
promoted to
of the
10th
state,
standard.
look here, the syllabus of the state board is completely different from the syllabus of CBSE. They will be made to study subjects which they have not studied. Or they'll be, at times, they will be required to study subjects which they have already studied. There will be overlapping. Are you playing with the lives of the students?
Please, my lords, not like that, my lords. We are, our school got affiliation under switchover category. Kindly turn to page 33 of their own document, my lords. Annexure.
Which are the which are the subjects that you are, which are the languages you are teaching them? To give you an example, which are the languages you are taught to the students?
My 18th section.
Which is the first language?
My lords, same syllabus, my lords.
It is not the same syllabus. State syllabus is completely different from central syllabus.
My lords, students who take up first language English will shift over to CBSE, my lord. Accordingly,
State syllabus, there is a compulsory Kannada as first language.
no, my lords,
If you have taught them Kannada as first language till 9th standard, and in the 10th standard, you are making them study something else altogether, is it?
no, my lords, students who opt to study in the CBSE syllabus, then only they'll go to CBSE syllabus, my lords. Who are in the first language English, then only they'll opt for CBSE, my lords. The affiliation itself is showing so, my lords. Kindly peruse annexure.
Even so, the science subjects, the social studies, the syllabus is completely different.
Students who opted CBSE, then only they'll go to CBSE, my lord. Tomorrow is the examination, my lords. Admission cards are already issued and they have.
No, you are playing with the lives of the students.
Please, my lords. No, we have not admitted any fresh student.
Or you have taken the state syllabus permission and clandestinely, because this is rampant in Bangalore, clandestinely you are teaching CBSE syllabus.
No, my lord. After affiliation only, the existing students who opted for CBSE, they were in CBSE syllabus. They are in CBSE syllabus.
So till 9th standard, they studied state syllabus.
Yes.
And for 10th standard, they have gone for CBSE according to you.
Yes.
18 students who opted CBSE, my lords, they are studying in first language English, second language Hindi, Kannada, science and other subjects, my lords.
Yes. So 10th standard Kannada, hitherto you have taught them state syllabus. In 5th standard, or rather 7th standard textbook, they will study it in 10th standard once again.
7th standard only, the compulsory Kannada, my lords. Thereafter, they'll other states.
Not in state syllabus, mister.
Now they also sought for late fee and we have paid 73,800 rupees as demanded by the authorities, my lords. This time it may be permitted.
My lord, contempt has been initiated. 39 rule order and under order 39 rule 2A, they have filed an application before the single judge. We are under tremendous pressure.
There is a provision, my lord, there is a provision in CBSE rules itself, my lord. They can take up straight admission for the 10th standard also. Direct admission, my the choice of the student, my lords. The choice,
18 students.
18 students.
18 students. Kindly, my lord, one submission. As per CBSE rules, my lord, there is a provision which allows the student to straight away take the direct admission to the 10th standard also, my lord. It's a choice of the student, my lord. These 18 students opted for CBSE syllabus, my lord. Kindly permit them to take up their examinations. They have already undergone the preparatory examinations. They are prepared for the main exams, my lord. Please. Preparatory examinations are over. Tomorrow is the main exam. Now state boards also, they will not allow us to take the state board examination. CBSE rules itself permits the students to take up the straight, direct admission for 10th standard merit who opted to study in 10th standard. That law permits. Now, by putting the delay fees, they are preponed the affiliation period and granted all tickets. Not the entire 9th standard students opted for syllabus. Only 18 students opted for CBSE syllabus. Order under challenge is already complied, my lord. Preponement of affiliation scheme is very much available in the certificate itself. From the very next month of affiliation, we are keep on making representation to the authorities to prepone the affiliation session.
Now it's for 10th standard examination.
Please, my lord.
When is the 10th standard examination scheduled?
15-2, my lord.
15-2.
15-2, my lord.
15-2.
Please, my lord.
The 10th standard school, course starts when? Started when?
From 1st April, my lord. June 24th, I'm sorry.
1/6/24.
Please, my lord.
When were you granted affiliation?
February 2024.
The permission was for you was to admit students for 10th standard.
No, my lord. Only for the 9th standard student.
No, my lord. First standard to
Only
10th
for the
standard.
9th standard.
First
The-
standard to 10th standard, my lord,
If-
it is in their own document.
Annexure D, page number 33 is very clear, my lord.
Hmm.
What it says that, my lord,
Affiliated for
Annexure
secondary
D,
school
page number
examination.
33, my lord. There is a table, my lord. The category is mentioned, my lord. It is a switchover category. Period of affiliation 1/4/2024 to 31st March 2029. Year and month from which admission can be taken in class 9. We are very specific, my lord, with respect of class 9. That is 1/4/2024, only for the 9th standard. Then year and month in which the first batch of class 10 will appear in the board examination, 1st April 2026. So those who have admitted for 9th standard, they would appear in the year 2026 for the 10th exam.
So switchover is not permitted in the 10th standard.
Switchover is not permitted under 10th standard.
It is permitted only in 9th
9th
standard.
standard. 9th standard student will study the 9th standard under CBSE scheme, and also they will study under the 10th scheme. It is the 10th standard syllabus under CBSE scheme, and they will appear in the
Does
year.
the law stipulates that a student has to get admitted? I mean, switchover is permissible only in 9th standard?
My lord, that is the bylaw what we have prepared, my lord, as well as the affiliation what it is provided for.
Okay.
Yes. my lord.
So 9th standard, your students have studied in the state syllabus.
Please,
Yes, madam.
state syllabus.
They have studied in the state
Excellent.
syllabus. As first language Kannada and third language Hindi.
First language English, my lord. Only the 18 students who opted for first language English are with their own.
First language English, second language Kannada, third language Hindi.
Yes.
Yes, my lord.
State syllabus.
Please, my lord.
We'll record it. You verify and state.
School authorities are here. English, Kannada and Hindi, my lord.
Which is first language, which is second language.
English is the first language, Kannada is the second language, Hindi is the third language
In 9th standard.
in 9th standard.
And in 10th standard, what have you taught them?
Same, my lord.
10th standard, what have you taught them? The state syllabus or central syllabus?
In 10th standard also, English first language, Kannada second language, Hindi is the third language.
Hindi is the third language. Now CBSE examination, they will be taking Hindi as the first language.
My lords, in 10th standard CBSE scheme, my lords, no third language, my lord.
No third language.
Please.
They will be taking what subject?
Second language is optional, my lord. Kannada or Hindi.
It's optional.
Please, my lord.
What about other subjects? You have taught them state syllabus or central syllabus?
Central syllabus only. Central syllabus.
So without permission, you switched over these students.
My lords, in the column itself, my lords, affiliated to secondary school examination, class 1 to class 10. That is the permission granted.
You have taught them with syllabus for this
CB
academic year, 24-25,
CBSE syllabus only.
for 10th standard students.
Please.
Sir. Day after tomorrow, the exam starts.
Tomorrow. Day after tomorrow.
Day after
the exam
tomorrow,
starts.
15. At their own choice, my lords, they have.
Tomorrow at 11.
Number 24, Sanjeev BL.
Lords, I appear for the respondent.
Lords, I have challenged the election by way of an election petition. My Lords, I'm sorry. 24, I'm sorry.
Lord, in this matter, my lord, the direction issued by the learned single judge, my lord, was to consider the representation page 20, my lord. Now, my lord, the representation has been considered, endorsement has already been issued. Now, my lord, they have filed a contempt petition, my lord, that has to be taken along with this. Contempt petition is also pending.
But what is this? What is there to challenge?
In writ appeal, my lord, we have already passed the endorsement, my lord.
That doesn't survive.
But the contempt is there, my lord, wherein
Writ appeal does not survive because by consideration of the writ petition, order passed in writ petition, they have issued the endorsement, my lord, which is subject matter before the Istanbul court in contempt petition.
Contempt is listed to.
No, my lord.
It's not listed,
Maybe
my lord. It can be called along with the contempt petition, my lord. CCC 1011.
Will also not survive.
Yes, ma'am.
Writ appeal does not survive.
Even contempt does not.
Contempt will also not.
No, I have filed a counter affidavit in the contempt petition challenging them a lot, saying that the endorsement has been repeated. What the order, the endorsement has been set aside by the single judge. Very same reasons have been assigned in the second endorsement, which is impermissible. I filed a counter affidavit, my lord, which can be looked into. Your lordship may kindly call both the matters together. It can be heard, my lord.
Both the matters. And this appeal as well as contempt petition number
1011 of 24.
1011 of 24.
1011 will be listed together on.
The date may kindly be known. Matter is pending, my lord, since from 2017. Appointment pertains to year 2017. Any short date may kindly be.
24th February.
Grateful.
27th February.
Twenty-five is urgent, number 26, the Sachin BS.
Lords, I have filed an election petition questioning the election of the Gram Panchayat. Lords, during the pendency of the proceedings, a recounting application was allowed and recounting was done. Lords, the court, after recounting of the votes, was found that I secured the highest vote and my opponent secured lowest vote. And court also makes an observation that the election has to be set aside since I secured the highest vote. However, my election petition was dismissed on the ground that before declaration of result, I have not made an application before the returning officer for recounting of votes as mandated under Rule 71. That is only the finding which is recorded by the court while rejecting my election petition. I preferred an writ petition. Writ petition was dismissed, confirming the order of the court below, on the ground that I have not exhausted remedy under section Rule 71. Perhaps the said observation is contrary to the mandate of the Apex Court judgment, 3 judges judgment of the Apex Court. Let's just pass over it. So what the Apex Court says is that, I'm sorry. My lords, just draw my lord's attention to the finding of the learned single judge. Page 25. I'm sorry. My lords, have a look at this is also a judgment. Page number 2 is the judgment consisting of 3 judges.
28.
Delay be condoned.
Delay is there.
Delays.
Who appears? Having
For
heard on
number 1 and 2, my lord.
respective parties, delay of 36 days, prayer for pondering delay of 36 days in filing the appeal is also to be for favorable considered favorably in as much as from the arguments made in the accompanying affidavit, passage of time leading to delay to the aforesaid extent is explained and sufficient cause is made out. Delay of 36 days is condoned, application is allowed. The writ petition, writ appeal may be listed on 28th of.
Number 27,
Writ.
Anand Kumar.
My lord, some personal inconveniences for the senior. 10 days time maybe.
27th February, March.
I'm appearing for this point.
Number 28,
28, on behalf of respondent number 1, I have entered appearance today. Should I kindly grant me a week's time, Lord, I'll get ready and I will inform my learned friend.
So when shall we keep?
Next week, my lord. Yes, next week sometime. The shortest possible, because my lord, my only concern is this, there's a direction by
13th
the.
March. 13th March.
Great. I'll just make one request, Mons. Now, there's a direction of the learned single judge to rehear the matter and pass orders within a time fixed period. In fact, the time has already expired. If my learned friend, the learned government advocate could look into the matter and ensure
My
that.
instructions are that proceedings have not yet been commenced from the last. First, may I have this matter next week itself?
Very
or
well.
it- it will
That's
make
my
up-
only apprehension. Otherwise, I'm not in any tearing hurry. I will find those directions at page 28 and 29.
Six months are over.
Yes, Manas, that will be the date of the order is 23rd July 24. We're into the 8th month now.
The appeal is pending, my lord. Notice is ordered. Probably they have not yet taken further steps in. Next week, my lord, any day, my lord, I'll make this.
Great.
Date. Only. 11th.
Sorry, what is the date? Was?
11th March.
11th March.
number 29, the Raghavendra K.
Appellant. Matter pertains to change of date of birth. Change of date of birth.
Change of?
Date of birth. The appellant worked in BBMP school as a music teacher. Her date of birth was.
Of birth.
Pardon me. the appellant worked as a music teacher in BBMP school, my lord. She has been retired. She has approached the SSLC board to change her date of birth from 2/10/1951 to 20th/10/1951. Only 18 days is difference, my lord. That is with, she has undertook to not to claim any financial benefit. Under that condition, she has approached the BBMP to change her date of birth. Thereafter, they have issued endorsement.
When did you file the application for change of birth?
2000, initially I have instituted a suit against the SSLC board and got the decree. Thereafter, I have approached the BBMP in the year 2022.
When did you file?
2022, man.
The suit is filed in 2013.
Suit is filed in 2013. I have approached BBMP in the year 2022. Man. After getting the decree from the, in the original suit. As per the original suit, the SSLC board has been changed the date of birth.
Okay. Dismissed.
Please, my lord. Lord, attend superannuation on 1/9/2001, my lord.
Yes.
So on account of the decree, my lord, a certificate has been issued with the rectified date, but with an endorsement saying that this will not come in the way or affect the service records. With that endorsement, my lord, then certificate has been issued as per page number 50.
What is issued?
A rectified SSLC marks card has been issued, wherein an endorsement has been made. Page 50 may kindly be seen. That as per the provisions of section 4 and 5 of the Karnataka State Servants Determination of Age Act 1974, they cannot place reliance on this decree for any service record purposes, my lord. There is a statutory provision. So relying upon that, section page number 50, a certificate has been issued, where an endorsement appears in Kannada on the top. Your lordship will find that, which says that for service record purpose, this will not come in the way. For other purposes, we are abiding by the decree.
Dismissed.
My difficulty is, my lord, in Aadhaar card and other documents like election voter ID, I have maintained my original date of birth. In the SSLC marks card also, it has been changed. Only in the pension record, it is showing different date of birth. And also, I have made a claim before the BBMP that I will not claim any financial benefits to that effect.
We'll deal with, yes, next.
Because my conscience is not permitting, because the date is 2/10/1951.
Hard learned advocate, Mr. So-and-so for the talent and learned additional government advocate, Mr. Harish, for the respondent upon service of the copy of the appeal in advance. The petitioner was music teacher. She took voluntary retirement 1/9/2001. Full stop. She had an occasion to file writ petition seeking to call in question the endorsement dated 22/2/23, whereby the request of the petitioner to alter the date of birth in her service record was not entertained by the respondents number 1 and 2.
Section 11.
It was the case of the petitioner before the authorities that her date of birth was corrected pursuant to decree passed in original suit number 4988 of 2013. The facts on record show that From the facts on record, it appears that pursuant to the decree passed, the petitioner had approached the authorities for alteration of date of birth and rest. What is SSLC? School living?
Secondary
Secondary-
school living certificate. Secondary school living
Secondary
certificate.
school living certificate was issued. The said school living certificate figures on record. Interpreted in XRG page 50. Full stop. It bears endorsement in the vernacular, which was explained to the court, to suggest that it was a condition put in the birth certificate that this would not be enduring valid. That the alteration of date of birth as reflected in the birth certificate would not endure valid for any service purposes. Full stop. Therefore, the entire prayer of the petitioner was full stop. Even otherwise, here in the service record, even otherwise, regulus section 4 of the Karnataka State Service Servants Integrated Determination of Age bracket or Act 1974 provides in its section 4 as under on quote section 4 bar or alteration of the age under the act. Full stop. Apart from all the above direct aspects operating against the petitioner, which would disentitle her to seek any relief with regard to change of date of birth in the service record, it is right principle that the long-standing entry regarding date of birth in service record cannot be altered at the back end of the service tenure of the employee, and the birth date could be changed to be permitted only within the time stipulated as may be allowed under the rules. Full stop. For all the aforesaid reasons, no error could be noticed in the judgment and order of law single dismissing the petition and not granting relief to the petitioner. The appeal is meritless. It is dismissed. Next.
30 is urgent. Number 31. Mr. Krishna S. Vas.
Challenging, my lords, the notification of acquisition. Parties are before this honorable court, my lords. There is a delay of about 288 days, my lords. They would concede with it. There is a delay of 288 days, my lords.
Delay
in preferring this appeal.
No, notice.
Notice has been already issued, my lords.
BDM, Lord, I represent BDM. Not, but may kindly take page 121. Not the reasoning, I leave it to you, Lord. The reasoning in the affidavit, I leave it to you, Lord.
So about delay what to be condoned?
Yeah, I really don't.
The same, right? Same affidavit for affidavit in delay application only. What is that?
Page 119.
Due to health related ailments. my lords.
I
But
20.
Master resources.
20.
No.
4. No. Oh, for further orders on content. IA number 24 of 1 of 24. Serial number 30. Is to condone the delay of 288 days, which has occasioned in preparing the appeal, which is late to be condoned by filing this application. In the accompanying affidavit paragraph, passage of time is explained by stating that upon dismissal of the writ petition by one single judge on 17/1/23, the petitioners, the appellants, reeled in shock as they had lost their valuable land, which was according to them, was only source of their livelihood. Full stop. It was stated that they had made arrangements to obtain the copies of the entire record, which took some time. It was further stated that the applicant was not keeping well and suffering from age-related health issues. Full stop. Therefore, also she could not take immediate steps for filing the appeal. Full stop. Stated that the land of the adjacent landowners has already been denotified from the acquisition. Therefore, if the petitioner is not permitted to conduct to prosecute his case on merits, serious prejudice could be caused to him. It was submitted that therefore also delay may be viewed in that context and may be condoned. Full stop. In overall view, it could not be said that petitioner applicant was indolent or negligent. Also, the passage of time was explained by stating that preparations were made to file the appeal and that the applicant was in indisposed health. Full stop. It could be full stop. No litigant would while away the time for the sake of whiling away when he seeks to enforce his rights. Sufficient cause is made out. Delay of 288 days is condoned. Application is waived. The writ petition may be listed now on. What is the matter?
My lords, subject of the matter is that there was an acquisition, my lords, which was a preliminary notification issued on 21/5/2008, and 18/2/2010 was the final notification, my lords. Whereas the property was not physically taken over by the Bangalore Development Authority and still continues within the possession of the appellants, my lords.
Good.
Compensation is paid. Compensation is paid.
Compensation is paid, my lords.
You have received the checks.
No, I have not received the checks, my lords. It is deposited.
That's what is recorded over here.
It is recorded.
And even in the course of argument, you wanted invoke section 38D. That's all.
Lapse of acquisition proceedings, my lord, Nadaprabhu Kempegoda layout, my lord.
Lord, similarly situated persons, my lords, sir. The writ petitions with respect to similarly situated persons, the acquisitions have been dropped, my lords, sir.
Whatever
Area.
you have received compensation. Compensation has been paid and you have received it.
Physically, the position had not, was not taken over, my lords, and it is the only land for livelihood of the appellants.
You have received compensation.
Yes, my lords.
That's it. Mazer is drawn.
Mazer is drawn on the Mazer, my lord, the landowners have signed.
That.
Please, now page 108.
Permission of the court. Serial number 33, we wish to withdraw because there is an NGT order on the same matter. So if I may be permitted to submit my memo of withdrawal, the responsible.
PIL.
Giving a copy. The NGT took suo motu cognizance of the same issue, and an order has been passed. So in that context,
Filing on record,
I'm
memo
also
dated
requesting to reserve my
13/2/25.
to
Learned
approach.
advocate, Ms. So-and-so stated that since NGT National Green Tribunal has passed order dated 24/1/25, taking suo motu cognizance of the very subject matter which is sought to be agitated and espoused and agitated in the present public interest petition, the petition may be permitted not to be prosecuted. To stop in view of the memo and in the facts emerging, the
One submission
Reserve my liberty
petition is permitted to be withdrawn.
with
permitted to withdraw, my lord. Liberty only if law permits. This is a PIL.
Post liberty.
She wants liberty for
I'm
what
seeking
purpose?
just in case, okay, it'll be a fresh
Okay.
cause of action.
That's
Okay.
dismissed as withdrawn accordingly.
ಅವರಿಗೆಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ ಅವ್ರು ಹೋಗ್ತಾರಲ್ಲ ಅವ್ರ ಗ್ರೂಪ್ ಅವರೆಲ್ಲ ಬನ್ನಿ ಸರ್
Yeah, my problem is
Pronouncement of judgment, seal number 1, it's a commercial appeal 51 of 2024.
Appear for appellant in this case, my lord.
For respondents.
Commercial appeal number 5124. Judgment and order of commercial court below, refusing the prayer to refer the suit dispute to arbitration. Does not require any interference. The appeal is fails, appeal, and it is dismissed.
Great.
Seal number 2, writ petition 18,593 of 2024, Sumoto PIL.
Here the dengue, my lord. Dengue, we have closed the proceedings. Court records a note of appreciation for learned senior advocate, Mr. K. N. Panindra, for acting as amicus curiae and effectively assisting the court in advancing the cause of this public interest litigation. Learned amicus curiae shall be paid a remunerative amount of rupees 55,000 by the state. Same order.
Passover matter, this is number 4. Contempt
I'm
of
appearing on
Madhusudan
behalf of-
M.
For the appearing on the complaint. Lord, the order is page number 9, dated 31st August 2024. Lord, the authorities has to consider the representation. The same has not been done in the time.
Notice 17th March.
Please, ma'am.
Seal number 83, withdrawal of contempt, Mr. Chetan V.
Nobody is there. Let it go to 17th March.
Seal number 84, withdrawal of contempt,
Nobody is there.
Mr.
18th
Shrikant NV.
18th March.
Seal number 85, Mr. Satish K.
Appearing for complainant minutes. They have not filed the reply minutes.
Have completed the order passed by the other single judge. This stating this petitioner will not. And it was communicated on 1/8/2024 to the petitioner, but she has not yet joined this duty matter. File affidavit in this regard. I'm ready and willing to join duty and we will file our affidavit.
19th March. In order to enable learned advocate to respond to file affidavit.
Please. Yes. Seal number 86, Srimati Praveena Kumari party in person.
Appeal is dismissed as meritless.
Seal number 32. Vignesh, this matter appear on behalf of plan.
Lord, I am agreed by the order dated, my lord, 3rd September 2024 at annexure, my lord, page number 31, annexure A. My lord, the appellant is a, my lord, nationalized bank. My lord, respondents are the borrowers. My lord, they availed a certain loan facility from the respondent appellant. My lord, later, my lord, they defaulted. My lord, we classified the account as the NPA, my lord, on 2/5/2018. Subsequent to that, my lord, we issued a demand notice and possession notice. And we have taken an order under section 14 on, my lord, 17/1/2019, and we have taken a physical possession of property. And my lord, we put the property for, my lord, multiple occasion for, my lord, bring the auction. However, my lord, for want of bidders, we are not able to, my lord, sell it. In the meantime, my lord, we have given a one-time settlement offer in favor of, my lord, respondents. That is at, my lord, page number 80. In fact, my lord, that certain timelines, my lord, which you have given, which they are not complied. Later, my lord, we withdrew it. My lord, we have issued the sale notice. My lord can find it page number 85. The first para, my lord, we are put the property for auction for recovery of rupees, my lord, 9.03 crore and 41,229,000. And 2 property, my lord, we put for auction. My lord, I am writ appeal number 1670, my lord, I am arguing. There are 2 writ appeal.
Writ appeal number
1670. First writ appeal. Wait. Lord, kindly come to page number 85. The sale notice, my lord, under Rule 86 of SARFAESI Act. My lord, for recovery of, my lord, 9.03 crore, we put the 2 property belongs to, my lord, respondent. My lord, in fact, we successfully conducted the auction. The present writ petition file on, my lord, 8/10/2023, my lord can find it page number 56, the petition. That's from my lord, page number 56. Prayer at my lord, 68. The first prayer, my lord, issue writ of or directions to pass the e-auction sale proceedings dated 28/8/2023 pertaining to so-and-so's property, that is, my lord, my secured asset. Second prayer, my lord, issue a writ of mandamus or order direction directing the respondent to consider and complete the process under one-time scheme as per the communication letter dated so-and-so and any other consequential relief. And my lord, interim order, my lord, kindly, my lord, next para, pending disposal of the above writ petition, it is prayed that the honorable court be pleased to stay all further proceedings, including issuance of sale certificate. In fact, my lord, when they approach this honorable court, my lord, learned single judge, my lord, that time sale already taken place. 25% of the money, my lord, auction purchaser paid. In fact, my lord, initially, my lord, interim order has granted, we filed a detailed objection. We stated all the facts, in fact, earlier rounds of litigation where the respondents, my lord, approached this honorable court, my lord, granted an interim order, that interim order not complied, that matter got disposed of. All the facts, my lord, we bought it. And even though, my lord, we have said that there is a remedy available under section 17. This honorable court, my lord, giving an opportunity and, my lord, after paying certain money, in fact, my lord, they matched the money where, my lord, I sold a property. My lord, there are two property which I sold. One property which I sold for, my lord, 2.6 crore, and the second property which I sold for, my lord, 4.6 crore, 4.06 crore. My lord, now I'll just draw my lord's attention to the order passed by the single judge, honorable single judge. My lord, I'll just, my lord, point out, my lord, relevant para from, my lord, page number 53. Para 8, my lord, in the light of the huge payment coming into the coffers of the bank, though with a delay, I deem it appropriate to direct the respondent bank to hand over the possession of the premises to the hands of the petitioner, both the residential and commercial, the subject matters of these petitions within 2 weeks from the date of receipt of the copy of this order. In the light of the aforesaid order, next para, my lord, since the auction purchaser has deposited 20% of the amount pursuant to the auction, the bank shall refund the same within 2 weeks from the date of receipt of the copy of the order, failing which the bank is bound to pay interest to the auction purchaser. The second respondent who is present in the court has received demand of rupees so and so, that he is auction purchaser, being the solution as determined by this court on dated so and so. In the contention of the petitioners, the respondent to initiate the proceedings to defend proceedings in accordance with law is always open, but it initiated the observations made in course of the order shall be borne in mind by the petitioners. Lord, I'll just point out, my lord, two aspects.
Sale is confirmed.
Sale, my lord, got set aside. That the honorable learned single judge directed me to, my lord, return the money, 20% of the money which he paid.
Sale in favor of the auction purchaser was confirmed.
Confirmed before, my lord.
Everything was confirmed.
Sale certificate agreed. That sales
certificate
was not issued. In view of the order, interim order.
This amount of 6 crore 17 lakhs.
No, entire money, my lord, what will happen?
Was paid when?
No, the entire money they are not. My lord, by the respondents.
By the borrower.
My lord, in fact, my lord, that order only speaks, my lord, that kindly come to, my lord, page number 53, 52 onwards, my lord.
It was paid subsequent to auction or?
Subsequent to auction, pursuant to the order made by the learned single judge.
Pursuant to order?
Order made by the single judge. Now, my lord, when, my lord, I classified the account in the year of 2018. Up to, my lord, 2024, my lord, I sold a property, my lord, the borrower never attempted to make any payment.
What is the law in this regard?
Please, my lord.
What is the law in this regard?
My lord, in respect of first and foremost, my lord, 13(8). Once I sold a property, I issued a sale notice under, my lord, rule 86. My lord, redemption they lost in view of recent judgment in the Bafna, Silir Bafna. I'll just, my lord, in fact, I produce a compilation judgment.
What was the amount due?
My lord, as of now, my lord, I have to recover approximately 4 crore. Approximately 4 crore I have to recover.
Yes. 4 crores.
Please, my lord. In fact, my lord, kindly come to sale notice.
Then you are getting more than the 4.
No. Total I have to recover 10 crore. My lord, when I put the property for auction, my lord, kindly come to the sale notice for a moment, page number 85. 85, my lord. Please, my lord.
You have not made purchaser a party to the proceedings here.
My lord, where writ petition was, my lord, very same. Writ petition, my lord, verbatically.
See,
my lord.
original order, come to ink page number 34.
Please, my lord.
In WP number 20387 of 23,
20387.
of 23,
Please, my lord.
purchaser was a party respondent.
My lord, in the connected petition, my lord, kindly, my lord, one more, there are two petitions which I filed because there are two writ petitions they filed. My lord, in the connected petition,
Anybody representing the purchaser?
He took the solatium and he closed it. He had no objection.
He had no objection with regard to it.
and it's a-
No. Purchase.
Purchaser, no?
Took 6.5 lakhs as solatium and he was directed to collect the remaining money from the bank. He had deposited
No, no.
65 lakhs.
my lord, my difficulty is this.
Then why should you?
I'll just point out, my lord, two aspects. In fact, my lord, this honorable court directed me to, my lord, return the money. And auction purchaser came, my lord, to me and we returned the money. That is not the issue here, my lord. My lord, in fact, the learned single judge passed an order to hand over the physical possession of property. I have to recover remaining 4 crore rupees. In, my lord, which I taken a position in the year of 2019. My lord, kindly see the, my lord, order passed, even there is no prayer. Without prayer, my lord, learned single judge passed an order, my lord. I'll just point out the order. Kindly come to, my lord, page number 53. Para 8. In the huge amount payment of coming into the coffers of the bank, though with the delay, I deem it power direct the respondent bank to hand over the position. My lord, kindly come to the prayer sought before the learned single judge.
Amount payable by.
My lord, as my lord, at the time of issuance of sale notice.
No, now.
No, my lord,
Four.
approximately 4 crore.
Approximately.
Please.
It will include all interest and all,
Etc. Yes, please, my
all penalty in it.
lord. All penalty.
Is it correct?
We have calculations error on that. What money I had taken was 5.5 crores. 5.5 crores.
5.5 lakh,
5.5, 5 crores 50 lakhs.
5.5 lakhs.
Please, that is what I had taken.
Very huge.
I have paid in 6.17 crores.
6.17.
Prior to coming to the court, I had paid 2.97 crores. In total, I have paid 8.97 crores now. Their claim is there is outstanding of 9.5 crores. Till date, my lord, there is no statement provided by them. My lord, the matter goes on for a year. There are 2 observations, 2 orders passed, my lord, where my lord, during the proceedings when I continued.
One second. Come to para number 10 of the judgment, page number 54.
Please, my lord. Please, my lord. The contention of the petitioner or the respondent to initiate the proceedings or depend proceedings in accordance with the law is always open. But if initiated, the observation made in the course of the order shall be borne in mind by the petitioner.
Now, the mortgage is not redeemed.
Please, my lord, I agree. My lord.
The
We both.
title deeds are still with you.
With me, my lord.
It was after all a mortgage by deposit of title deed.
Please, my lord, in fact, along with the documents, original documents.
Along with the original
Please, my lord.
documents. It was not
Please, my lord,
superficial mortgage or anything like that.
Please, my lord.
That being the case, give them the statement of accounts.
We'll provide, my lord. In fact, my lord.
If you have to proceed against them in accordance with.
In fact, my lord, I made a submission before the learned single judge. In fact, a statement of account I produced. You know, if it is required, once again, I'll produce it. My lord, in the sale notice, we indicated that 9.5 crore is outstanding, approximately 9.5 crore is outstanding. And the original application allowed in my favor, the debt has been already determined.
Counsel, listen.
Please, my lord.
See, you're not expected to act like a private money lender. You're not here to gobble up the property of a borrower and make merry out of it. Now, here is a case, if the auction purchaser was breathing down your neck, we would have understood. He has no grievance. He has taken his money and he has gone.
Please, my lord.
They have borrowed the money from you. They have committed default.
Please, my lord.
You made it an NPA.
Please, my lord.
Later on, it resulted in this litigation. They have paid certain amounts to you. This litigation has not foreclosed your right to recover your dues from them. Liberty is also reserved for you to go in accordance with law. Are you interested in your money or gobbling up their property?
Only money, man.
Only money,
Only
na?
money. Certainly.
Then give them the statement of accounts, issue a notice and proceed against them in accordance with SARFAESI Act. Liberty is reserved to you. After all, the property is not redeemed from mortgage. This judgment does not have the effect of
My lord, my only
cancelling the mortgage.
please, my lord. In fact, my lord, in respect of sale, my lord, we don't have any problem. My only difficulty, my lord, handing over the possession of a property, which I took, my lord, 2019.
What were you doing with the property? Were you utilizing it?
No, my lord.
Have you leased it?
No, my lord.
Have you put up a...
No, my lord.
Then?
For the remaining recovery of, my lord, 4 crore rupees.
Look, mister, you are not a private money lender. If they cannot utilize the property, if they cannot run a hospital over there, how will they pay your dues? You are not here to scuttle the business. You are here to promote the business. At the same time, why do you go for modifying the loan conditions? One-time settlement, why do you give? Taking into consideration the economic crisis, what the industry is facing, and things like that. If they are out and out fraud people, they don't want to repay your amounts, you invoke all the provisions coming to your aid under SARFAESI, go against them. Now, admittedly, more than 60% of the dues, according to your own dues,
It's fact.
more than 60% of the dues has been paid to you with the current interest. It is not when it was made NPA. With the current interest, more than 60% of the dues is paid to you. If 60% of the dues were to have been paid to you, then itself, question of making it NPA would not have arisen. What type of attitude is this? Are you here to make them paupers? Are you here to sell the property to a person of your choice and should we facilitate your officers make money?
Lord, I'll just make
What type of litigation is this?
I'll just make only one.
Your right to recover is not foreclosed. This litigation resulted in you recovering 60% of the amounts according to you only. Now the property is in their hands.
Property with me, my lord. So far, I'm not handed over the position of the property.
You hand over. Then you invoke it once again. Why have you not handed over so far?
Lord, I'll just, my lord, make it to submission before the submission.
It's a property on which hospital is running,
Not
right?
hospital, it's a hotel.
Bar and restaurant. Bar and restaurant with a lodging.
Hospitality or
Hospitality.
Hospitality.
Oh, sorry.
Bar and restaurant with
I
a
thought it is
30
hospital.
lodging facility. My lord.
They will make even more money there.
My lord, that is what even learned single judge had denoted, my lord. It's in electronic city, my lord. There are 850 companies. And I would have written.
Provided BBMP has no objection because bar and restaurant is coming up anywhere and everywhere.
It's closed for 4 years, my lord. I would have made money and returned the entire amount.
May make
to
only
them.
one submission, my lord. My lord, in fact, before the learned single judge, also I made a same submission. For remaining money, let them some undertaking before them.
Let us understand two things.
Please, my lord.
Firstly, why there is so much gap between your calculation and their calculation. Number two, are you interested in litigating only?
No, I'm not at all. I'm, my lord.
Is there any OTS available with you?
Right now, we don't. That's what. My lord, let them approach me.
Your higher
Look,
ups must have power to settle.
My lord, in fact, my lord may direct me. Let them come with, my lord, some proposal. We'll consider with all fairness.
What was the original loan?
My lord, originally we sanctioned, my lord, there are two loans. My lord, I'll just, in fact, my statement of objection which I stated. Lord, kindly come to my statement of objection which I filed before the learned single judge.
Your higher ups must have power to wind up the things.
Please, my lord.
Your higher officers must have powers, legitimate powers to wind up all these things.
Please, my lord, let them come with one fair offer. As on today, approximately 4 crore is outstanding. Let them come with one offer, my lord, with all fairness, we'll consider and we'll close it.
Counsel, for how many years did you lend the loan for?
My lord, My lord, kindly come to, my lord, the sanction, my lord, which is given, my lord, kindly come to page number 130.
Now tell me, what is the loan sanction, total loan sanction?
There are two loan. One is, my lord, 3 crore. My lord can find it, my lord, page number 130.
Next loan?
I'll just point out, my lord, in the document.
Lord, even according to their statement of objections, 2 crore and 2.8. 4.8 crores is what was sanctioned to me.
4.8 CR.
Please, I have paid 8.97.
In the year
When was the sanction?
8.97.
2015.
Please.
Huh?
2015.
In court 6.16, I have paid. In court
2015.
6.16.
Okay, interest rate?
Coming to court 2.97.
Interest rate, my lord,
You almost recovered the double.
Please.
No, that may not be criteria, but you have recovered substantial and they have paid substantial. Substantial in true sense of the term, not just for the sake of saying.
What was the period, duration period for repayment of the loan?
just point out, my lord, in the document itself. Please, my lord.
Interest rate and duration within which they had to repay the
My
loan.
lord, the first mortgage, my lord, at page number 123.
Counsel, you are required to have this in your fingertips.
No, my lord, in respect of debt, my lord, it is, I don't think so. They will, my lord, dispute and.
So we are asking you a question. It is asked with a purpose. Madam, what was the duration? Duration of the loan?
The duration was 3 years, my lord. I was required to pay. They declared my account as NPA in 2018. I availed the loan in 2016. My loan is declared as account is declared as NPA in 2018. And then COVID hit, my lord. We couldn't repay the amount as it was a lodging facility.
It was a short-term loan, is it? Only 3 years?
3 years, ma'am.
Only 3 years. Mortgage remains with you. What more guarantee you want?
My lord, that observation may be given, my lord. In case, my lord, if they're not coming under one-time settlement or a payment of remaining money, which, my lord, I'm entitled.
See, work it out for your sake also.
Please.
Wherein it's either one-time settlement or redoing the entire loan procedure.
My lord, may make one submission. To make this 6.2 crores, my lord, he has sold everything what he had. Because he had to retain the house and the commercial property. Commercial property has, it's a lodging facility with 30 rooms and bar and restaurant. Both are shut from 2020, my lord. Even to give any offer, my lord, I would require the bar to be operational. For reopening the bar, I need 2 CR because it's shut from 4 years. Whole of my 30 rooms are locked.
This particular.
But my lord, before this writ petition, the borrower, my lord, earlier rounds of 2 rounds of litigation approached this honorable court. In fact, both occasions, this honorable court granted an interim order subject to deposit of certain money. My lord, the first writ petition, my lord, 23878 of 2022, that is, my lord, this honorable court granted an interim order on 30th 11/2022, subject to deposit of, my lord, 15% and 10% within 3 weeks. They're not complied. The one more writ petition, my lord, filed, my lord, writ petition number, my lord, 215 of 2002. My lord, my only submission before this honorable court is, my lord, he was cleverly waiting till I'm selling the property. I put the property, my lord, multiple occasion. I'm not able to sell it. My lord, once I sold the property, they approached this honorable court.
The factor which will weigh against your every argument is that the auction purchaser is not interested.
Interested Allah. My lord, he was very much interested before the learned single judge. Learned single judge directed him to accept the money. He accepted and is gone.
You can't argue all this.
No, I'm not saying, my lord. In fact, before the learned single judge, he was, my lord, in fact, he appeared through his counsel. He was said that I'm ready to pay the entire money. I don't think so. My learned friend will dispute on this aspect. My lord, in fact, learned single judge directed me to return the money, which we as per the directions, my lord, now I'm not on sale. My difficulty, my lord, handing over the possession of property, he will never pay my remaining money.
Today, when the appeal comes up before us, things are simple. The auction purchaser is out of the
Please, my lord, it's fact.
zone of dispute. They have paid substantial amount. The property still continues with him. Mortgage, mortgage. And you are given liberty to proceed. Of course, subject to what is observed in the order. So the scales doesn't tilt in your favor. As on date when we are considering the.
My lord, I'll make only one submission. I'll come with a statement of account what is outstanding as in today after, my lord, giving all the benefit which you made, my lord, have it tomorrow. Let them give some offer. What is the money they're going to pay, my lord? It can be settled before my lord only.
We are not able to suggest them because the gap is too.
No, my lord, that debt, my lord, it has been.
Wide.
Allah, my lord, the debt, my lord, determined by the DRT.
So we suggest you to give,
Lord?
rather than we asking them to give. Take a call, both of you, 19th, or little more also, you know.
Kindly have it on 24th, 1 week, because the institution,
But we have waited this long, my lord. We'll wait for the possession to be given to us.
will come.
But the entire thing is getting settled well and good. So that is what.
Yes. My lord, I have put for the difficulty of the respondent, my lord. There is no money with him because he sold the entire thing, my lord, to take possession of these properties.
Let us see what is the offer.
Please,
what is
please.
the- Whether you get considered.
Please,
See, it can be
Understand.
40 years, it can be rescheduling of the loan.
Please, my lord, I understand.
24th.
24th or 25th, any day. 25th, my lord. 24th, I'll be not. 25th, my lord.
Why not 20th or 21st?
21st, I'll be not in station. That's one small difficulty. 25th, my lord. Grateful.
Great. Lord, in the meantime, if they can share the statement with us, my lord, please, oblige.
Grateful.
Thirty-three is disposed, number 34. Mr. Ganpati Bhatt.
In this case, my lord, I am appearing for petitioners. My senior has argued in this case last time. Have it day after tomorrow, my lord. He is engaged in other court, senior Odeholla.
When?
Day after tomorrow, my lord. On Monday,
21st.
21st. Much.
35, 36 are urgent. Number 37. 37.
It's appearing for the state in this. This was a disposed of matter, my lords, in which there was an interim order granted, wherein the money which was deposited was released. Now there is an impleading applicant who has approached the court, my lords. That's why the matter is listed.
My lord, appearing for the applicant. So, my senior, he's not aware.
1996 matter, and
So if this case can be posted on Monday, senior will be available.
And this applicant, my lords, who is now filed this application, had already challenged the order of the deputy commissioner before the Karnataka Appellate Tribunal. And he's lost it there, my lords. And now they have filed a writ petition also. Writ petition is also pending.
So nothing will.
Nothing they hear, it will not.
Nothing.
They have, that is still pending consideration. This is the order of KAT, my lords. Same Chamundeshwari Charitable Trust.
My lord, my senior is not available. Kindly post it on Monday, my lord, please. Request you to post it on Monday.
They have
He'll
filed
be
a
here.
writ
He'll
and
be
they
here
have
for
also-
sure. He'll be here for sure, my lord. one opportunity, man. One opportunity.
What you have done to your gown here?
My lord,
Your gown, what you have done?
sorry, my lord, I'm not able to get it.
Fashion or style? No, your senior is not here. When senior will be? 19th at 2:30?
Monday will be here.
Good, 19.
Obliged.
Much obliged. Thank you, man.
Number 38.
May it please, my lords. This petition was earlier filed in 2022. And it's a continuity of an earlier petition that was filed in 2011.
Not listed. Here it is 45915. It is right. This is good. Why it is? So today what is coming up? Petition?
My lord, in April 2024, I filed an application seeking cancellation of the concession agreement that was entered between BBMP and the developer Maverick for not complying with the order of this honorable court. And
I've not
I've-
been served with a copy of the IA, my lords. That's the office objection that has
I'm
been.
sorry, my lord, they're taking, on 16th, one more copy was given to them in the court, 16th of December. And the prayer that I'm seeking is not going to affect them, my lord, because I'll just give a brief history, my lord. The developer promised to develop 16.5 acres of land on a joint development with BBMP, the land belonging to 1,512 economically weaker section of family. Way back in 1996, 1,512 apartments were allotted to economically weaker section who were employees of the BBMP at that time for a consideration of 30,000, and registered lease cum sale deed was executed and possession was given to them. In 2003, my lord, one block collapsed out of 42 blocks. And the entire 1,512 were evacuated and made to live in the payment. From 2003 onwards, they had no shelter. Even now, they have no shelter. We filed writ petitions out of writ petitions. In 2009, there was an order passed by this honorable court directing the government to rebuild the structure, which was not done. BBMP invited a tender to have a public-private partnership to develop the property. The 22 acres of land surprisingly shrunk to 16.5 acres, 16 acres. And the contract was given to the developer Maverick to put up the structure. And we found that it was not at all, because instead of 1,512, it was supposed to be more than nearly 1,700 apartments were to be built beyond the 1,512. And certain things, when there's no clarity, we are not parties to it, though 1,512 families have interest because they've registered interest in undivided interest in the land. So when we filed the writ petition, matter came before this honorable court. The connected writ petition also before your lordship. The lordship at that point of time observed very clearly the land belongs to 1,512 families, and what right did the BBMP have to enter into a concession agreement with a third party and into a public-private partnership. Thereafter, matter was heard at length, and ultimately, my lord, it was felt that BBMP declared that they have no money to put up the construction. Government also said they did not have money to put up the construction. And a proposal was given by this honorable court. There were at least about 200 EWS people in the court at the time. The biggest mistake I made, my lord, was at a suggestion made by the developer saying that when BBMP, sorry, my lord, saying that they have no money, at least let them get a roof if part of the land is allowed to be developed for EBS. And poor people, my lord, even now there are cobblers, daily coolies. They agreed, at least let us have a shelter. So we entered into a compromise agreement wherein 50% of the land was supposed to be developed for EWS and 50% to be constructed for commercial development by the developer. The condition was, my lord, within 2 years, they'll complete the structure for EWS, then take up the development of the commercial structure. One pretext or other, they were dragging a feet. From 2012 till now, we have not seen the roof at all. Now, we filed contempt petition, and I have now material record to show the Honorable Lokayukta has filed a detailed report, and they've been misleading this Honorable Court, even in the contempt proceedings, blaming that BBMP has not given the permission. BBMP blames PDA for not giving permission. We now discovered that the mischief was the developer virtually had a tacit understanding with a third-party developer who wanted to increase the floor area ratio, altered the terms of the concession, and that delayed the entire process. Today, what has happened is, in April 2024, I filed this application because the last order was passed by in this matter was the learned senior counsel for the developer gave an undertaking that within 18 months, they'll complete the structure, which has not happened to this day. I'll produce the documents. And may I just pass on the Lokayukta report, my lord? It's already given. All sets were given to my learned friends at that point of time. Give me this. Where's my flag? Flag one. The urgency in the matter, my lord, what has happened is the developer, though the condition is that they should first build the EWS quarters, the building, developer goes and mortgages in collusion with certain officials of BBMP to the restrict of 50% of the.
Main petition.
Main petition is my lord's WP 18504 of 2020.
It is also before my lords.
What is that? You
My
didn't
lords,
have the copy of IE?
we've not been served with a copy of the IE, my lords.
My lord, everything has been served, my lord. This is
not
last time
respondent
on
number 3, my
16th
lord.
December when this matter had come up, same prayer was made across, I submitted. I will do it, but the urgency is, I'll just give. There is a finding which they cannot deny. There's a Lokayukta report I just forwarded. They have illegally, fraudulently mortgaged the land for 300 crores. They, in the sense, the developer and certain officials of BBMP without the permission of the government. And they have perpetually committed default. They have, developers brought Section 13 of SARFAESI Act into our place. The bank is a NBFC, non-banking finance company. My lord, I can demonstrate. There's another writ petition I filed because I moved this matter. And then I had to file another writ petition, which is pending before the learned single judge. It was demonstrated the entire loan was collusive by the own affidavit they have filed before NCLT. A 300 crore loan, which was supposed to be sanctioned by India Bulls, now as Saman Capital, out of which 140 crores has been diverted by the so-called Saman Capital or India Bulls to another developer. The developer has got has entered into a tacit understanding with this developer, big builder. And we discover now The NBFC is controlled by this big company, where there's a kickback of 130 crores. Who has filed it? In the NCLT, the developer subsidiary company has filed an affidavit. That is part of the record before the single judge. Now, my fear is, now the developer, the NBFC has invoked section 13(4) and has moved the learned magistrate to take possession, and the order is posted tomorrow, my lord. Give the copy. Sorry, my lord, because of paucity of time, I could not make a formal application, but the entire detail is here.
To give copy to
1,512 copy. Please give them copy. 1,512 families will be at street once a third party right is created. I can demonstrate there is this absolute collusive sham transaction. It is by their own affidavit before the thing. And I was also given to understand, my lord, I also request my lord to consider the order passed by the report of the learned Honorable Lokayukta. The Lokayukta report I've been fighting this case pro bono since 2010. I can't bear these people suffering, my lord. My conscience doesn't allow me to sleep. I'll rather stay in this court at whatever cost it may be for me till I get, the only recourse they have is my lord's here. May I take my lords to page 66 of the Lokayukta report, my lord. The developer has no say at all. They have just passed on the buck to the financial institutions because there's a collusion between them. Page 66, internal page 66, para 61. It is the case of MHIPL, the contractor. My lords got it? Page 66 of the Lokayukta report, my lord. Ink page, that is internal page 66. Para 61. May I, my lord? Yeah. It is the case of MHIPL, the contractor, that in view of the shifting of the Bilagalway and HT line from middle EWS quarters to the edge of the project site, and also for the construction of commercial building, it has sought for modification of plan from BBMP as well as from BDA. It is relevant to point out that the development agreement relates to total extent of land measuring 15.72 acres, out of which approximately 8 acres was reserved for EWS quarters and remaining was for commercial purpose for the benefit of both BBMP and MHIPL. The contractor, in terms of the joint development, each one of them sharing 50% of land. It is useful to extract the schedule 2 of the joint development agreement set out in schedule given to the agreement which reads as under. I'll just skip that, my lord. On 29, para 62, on 29/6/2019, BDA sent a proposal to the government seeking approval of the change of plan use with 70% and commercial and 30% residential construction. This is the mischief they did. However, the government, by means of its communication dated 19/10/2000, addressed to the Commissioner of BDA, refused to approve the modified plan proposed by MHPL contractor. The decision of the government appears to me refusing to approve the modified plan as proposed by MHIPL contract was justified in law, as BBMP and MHIPL were governed by the terms of joint development agreement. In my view, it was not permissible for MHIPL contractor to seek for modified plan in terms of the as sought for by it. At any event of the matter, seeking for issue of modified plan as stated above cannot be a ground to delay the construction of EWS quarters, in respect of which BDA had issued development plan and the BBMP had issued a sanction plan and license, and MHIPL commenced construction of EWS quarters. The very attempt.
Yes.
Wait a second. May I also take my lots too? Page 82, my lord. Page 82, my lord.
Now, the concession agreement that was entered into with the developer
Yes,
What
my
is
lord.
the right granted in favor of the developer?
So the right granted, my lord, was to develop 50% of the land. The condition was that to develop EW, first put up apartments for EWs and others also.
See, Mr. Thiruvangadam, it's like this. Number one, they are conferred certain rights by virtue of the concession agreement. The developer is conferred with certain rights.
I know.
By virtue of the concession agreement, which is a registered concession agreement.
Yes.
Now, they are at liberty to mortgage their rights.
In the normal circumstances, yes. But let me tell you, my lord.
But they cannot mortgage your rights.
No, what has happened? There was a condition to it. What is the condition? My lord, the first condition is that they should first put up the EWS building. Then only to go for commercial. Now, what they have done is they put the cart before the horse. They have not done anything of a construction. They go and borrow 300 crores. And this is against the contrary to the orders passed by this honorable thing. The concession agreement itself is bad in law. For the simple reason, the land did not belong to BBMP exclusively. Prior to that, from 1982 onwards till 1996, BBMP has executed registered lease cum sale deed with undivided, proportionate, undivided interest.
See, whatever they do, whatever the banks do, it will be subject to whatever rights you have got over the property.
Very well. I'll explain. I'll explain the present situation. From 2012, we are in 2025. Where is my roof? First and foremost, they should answer this honorable court that the compromise that was reached, not the concession agreement. Concession agreement was entered behind my back. Though 1,512 families had a right in the land, they were not taken into confidence. They entered into a concession agreement to develop, I will rather say, our land, which BBMP could not have done it at all. One. Second, the finding of the Lokayukta report is very, very clear that it's totally illegal as such. Second, BBMP had no right under the law to mortgage the land, because when does the land vest totally with the developer? The land will vest as per the concession agreement, as per the, not for the concession, as per the compromise order passed by this honorable court, that they have to complete the EWS quarters first. The conditions, orders, compromise that was reached before this honorable court, plus the order passed by this honorable court very clearly says the concession agreement stands altered subject to the compromise that was reached. So the condition is that they should have built the quarters first. Had they done it, and then they have gone for mortgage of the other land, we have no issues at all. We have no issues at all. But they have not done it. And as the Lokayukta report says, they tried to modify and started doing the development of the commercial end without touching the EWS. Kindly come to page 82.
Now, what is sought to be, sale is not ordered yet.
Sale is not ordered. What has happened, my
It is
lord,
to take possession of the property.
they are taking possession of the property.
Okay. So you sought to implead
yeah, I filed an impleading application to bring the thing. When I moved the matter before, I filed this as application for cancellation of concession agreement because violation of the terms of concession. Within 2 years, they should have developed the project from 2012, which they have not done. We waited patiently. We filed this, the second petition.
This IA 1 of 25.
IA 1 of 25. Yeah, for impleading.
Notice it not yet ordered.
Not yet ordered. But in the previous thing and the previous IA of 24, that also notice as order because it had not come before this honorable court till 16th of December. And the matter came before 16th of, there's so much of water has flown. We discovered that the mortgage has happened. A section 7 petition before IBC was filed to appropriate this land. Then for some reason, because there's an allegation made between the developer and the borrower that 300 crores out of 300 crores, 140 crores has been siphoned out back to the thing. we have got this. Then we are no other go because we wanted to challenge the process under section 17. We filed a writ petition that is still pending. Notice was issued. The learned single judge asked us to file objections to the 13-2 notice. We filed our objections to 13-2 notice. Thereafter, when the matter came up, then the learned single judge said, go and agitate before the NCL, before the DRT. We went and agitated. By the time, one of our individual member, he filed an application. The application was rejected, saying that you have no jurisdiction. And that is, they have no jurisdiction. It has to go to Chennai. My lord, where will we go, my lord? Kindly see page 82, my lord, para 82. I'm for the petition, ma'am. Notice had not been ordered. My lord, may I just, my lord's kind indulgence to para 82 of the Lokayukta report, my lord. That will answer a lot of your queries. Para 82. Implementing an application not had been allowed, my lord. We filed it in January. No, my application, my lord. In December, when a matter came up on 18th, my lord said file an impleading application to implead them. Very well, my lord. I filed an application, but my lord, kindly, I request my lord to see para 82 of the Lokayukta report. Lokayukta report. My lord, kindly see, tomorrow is the execution of the order under section 14. Just 2 minutes, my lord, I will not take more time. There is a finding that the mortgage is illegal by the Honorable Lokayukta. And there is a direction by the single judge also, I was told, in another writ petition that asking the government what is the thing, let the, I think, additional advocate general is also present. They should state, my lord, basically, because this is what it says.
My lords, they have impleaded now, the prayer is, there is a matter before the criminal court wherein these lands will be, possessions will be handed over to another party from the respondents, my lords. They're saying that they do not have the right over those properties. In those criminal proceedings, this possession of the lands are being handed over to that petitioner in that case. That is the reason they have moved the matter. Criminal matter is coming up tomorrow is their grievance.
My lord, can you see, para 83, it says, further material on record shows the mortgage of 3.8
I appear for the developer, my lords. If they serve me a copy of the IA, I'll file objections to that, my lords. The matter will be had on Monday.
Let there be a stay, even for a short period, let there be a stay of the proceedings before the learned magistrate. My lord, after that is that, because then the entire apple cart will be turned. Kindly bear for a minute the para 82 and 83 of the Lokayukta report, my lord. If I am wrong, then you can hold me. My lord, kindly see, the observation is section 176 of the Karnataka Municipal Corporation provides for disposal of property interest therein by way of sale of transfer. So it is useful to extract so and so. And it says, the BMRCL by means of letter dated 6/4/2008 only informed the additional chief secretary of Government of Urban Development Karnataka regarding execution secondment. There is no material on record which prima facie shows either BMRCL or BMHL has obtained prior permission of the government under 170 of the KMC Act for certain creation of mortgage in favor of India. Therefore, it prima facie appears to me that fastening of liability to the property in question by creating a deposit right is unauthorized and without the authority of law and would not create any right on the property. This is a finding of Lokayukta after conducting a detailed inquiry. My lord, let that be a stay at least tomorrow, my lord. It's not a haste, my lord. Let there be a stay for orders tomorrow and a date may be fixed, my lord. And also earlier application for cancellation of concession agreement. Oh, that's already done. At least give me the liberty to move the agitate before the learned magistrate, my lord. My lord, because section 14 does not empower us to do so. The thing is, not only I'm protecting the interest of 1,500, land belongs to the state and BBMP also. That's what the Honorable Lokayukta also said.
Yeah, and including because you are trying to interject several processes.
No, my lord, who is 1,000 from 2012, they have deprived our shelter. Flight of at least let that be. I'll take my chance there, my lord, because kindly appreciate, my lord. Unless and until an observation is made, my lord, flight of 4 people, my lord, 1,512 families. 23 years they are shelterless.
Number 39, Mr. Girish Kumar R.
Respond about 10 years.
Respondent number 9, 11, my lord. Yesterday I filed an wakalat on behalf of respondent 11. I have not received any copy, only the, my lord, the notice, court notice I have received it, my lord. I'm not getting.
I appear for the 10th respondent's counsel. Our reply has been filed. If your lordship's permit, we'll just file an additional reply. Some few more documents need to be placed on
We
record.
are keeping on 24th March, file whatever you want to file.
So great, so great.
Your Lordship, I'm appearing for the respondent number 2 board. Copies have not been served upon us to take instructions in this matter, Your Lordship.
For me also not, they are not served.
They will serve.
Careful, Your Lord.
So number 40, Mr. G.R. Mohan.
For the petitioner, in this the counter update is filed by the BBMP, wherein they stated that they will remove all the, kindly see page number 4 of the update filed by the BBMP. Para 8. It's in the lake, they allowed all the dumping of other things and construction of roads. The 12th July filed by them, Your Lordship. Only that limited purpose, the court can, if they have to remove all those things, if they do it, the petition can be disposed of. Page 4, Your Lordship, in page 4 of the affidavit filed by BBMP Chief Commissioner.
Page 4 of?
Page 4. Page 4, paragraph 7 and 8, Your Lordship. 7 and 8 in that affidavit.
Regarding para 8, my lords.
7 and 8.
8, the garbage collection is happening outside of the lake.
No, just para 7, Your Lordship, may kindly see. Para 7 of the affidavit.
7 of?
Para 7 of the affidavit filed on 12th July by the Chief Commissioner BBMP. Page 4, in page 4, Your Lordship. Para 7.
Where is 12th July?
My response, my lords. BBMP's response.
12th July, yes.
Yes, ma'am.
Yes. So this pertain to 72 acres of water body to be maintained by the direction by the court. Para 7, Your Lordship. I state that, Your Lordship got it.
Yes.
I state that sleepers, iron gills, meshes, pillars present inside the tank lake area will be removed as early as possible by intimating respective department. Because these are things which I highlighted earlier. This was filed about almost 6 months back, 12th July 2024, Your Lordship. Then para 8, I state that the garbage collection autos are only parked at the extreme north side adjacent to the main road, only to shift the garbage to truck, and same will be stopped as soon as the new gate is built at the northern side of the Malatali Lake. The photographs of north side is enclosed. So these two issues basically, and also labor sheds, para 9. If they are complied with it, the petition can be disposed of. Because they themselves are undertook in this also. Para 7, 8, and 9, Your Lordship.
See, page number 55,
Yes, sir.
56 and 57.
Yes, Your Lordship.
They are the directions issued to BBMP.
Yes, sir.
Now, of the 6 directions issued to BBMP,
Yes, Your Lordship.
according to you, what is the direction which is not followed
No,
by them,
the
implemented
direction,
by?
Your Lordship, is that at page number,
Come to page number 55, 56, 57,
No.
sir.
kindly see page number 55,
Hmm.
para 15. Though the order passed by this court on 24th November does not prohibit construction of it, it does not mean that the authorities cannot grant permission to construct either temporary idle or any construction in view of the bar under section 12 of the also. As rightly submitted by the learned senior counsel, for response, the construction of Kalyani waterbed shall be used only for immersion and Durga idols and for traditional and ritual purpose. In that, now, Your Lordship, in this affidavit, now they say in para 9, Your Lordship, para 10.
Sir, that is not the direction issued. Direction issued is subsequently order on the
Yes, Your Lordship.
thing called order over here.
Yes, Your Lordship.
Page number 55.
Yes, Your Lordship.
There are 6 directions issued.
Yes, Your Lordship. The direction, Your Lordship, page number 55.
Of the 6 direction, which is the direction that is violated by BBMP, according to you?
The authorities also shall not permit any individual or any group or any political party to use the tank area for recreation or celebration, so also ensure protection of the tank. For this, they again next year they permitted, I produced all the photographs. They permitted it, again recreation for Shivaratri. Again now the another Shivaratri festival, they are allowing it. And then as admitted by both the parties, since the total area of the tank is 71.18 acres, except the dispute is respect 3 acres as it was also pending was the water spread area of 42 acres, which is now increased to 40, should not be allowed to decrease, and authority shall ensure that no individual or group political shall be allowed to construct any permanent structure within the tank area and or Kalyani Pontuva. Now the Kalyani, what they are saying that we are using it as an amphitheater, para 10 of the affidavit. That cannot be done. That's what the Samar court made it very clear. Only for the purpose of immersion of idols during Ganesha or any puja, it can be used, and afterwards the water should not mix with the lake and it should be cleaned. Now, para 10, Your Lordship, of the affidavit filed by the BBMP says it is used as amphitheater. Page number 5. I state the Karnataka is using way it can be used as amphitheater. Kindly see the page 5, para 10, Your Lordship. When the court has made very clearly, you can't use it as any as a amphitheater. Your Lordship got it. Para 10, page 5 of the affidavit. Para 10, Your Lordship. I state that the Kalyani is built in a way, it can also be used as amphitheater. When the court has made it very clear, you can't use it as an amphitheater. The Kalyani is surrounded by concrete and fencing will be completed in the near future. They are not closed it. Because earlier the court directed them to put it in a fence. Similarly, toilets were built temporarily for the occasion of Shivaratri this year, and the same will be demolished as early as possible. Now, even it is being continued even now also. The toilets are not removed. Para 10. They admit.
Now
If
respond.
your lordship see the rejoinder,
What do you want to do?
Nothing, my lords, there is no violation of any order here. The Kalyani which is used is a concrete structure by itself because that was built with the approval of this honorable court only, my lords. There is an order which is passed that the Kalyani can be built there. The Kalyani is used sometimes when we fill the water because we do not want the tank area to be polluted with any kind of religious functions and others. Maybe it is the immersion of a Ganapati or in, so we have built a separate Kalyani which can also be used as amphitheater. It's a circular kind of structure where water is filled in during Ganapati Puja or Durga Puja, and water is because those are at a distance. This water will not really merge with the water of the tank.
Now, Kalyani is not part of the tank or what?
It is a part of that survey number. It is not part of the tank alone. I'll show you the map, my lords.
that photograph which I produced now, it is not closed, that Kalyani is not closed, your lordship, in the rejoinder affidavit. It is not closed, it is still kept open.
One copy if I may forward this.
No, do you have any photograph showing where the tank is situated and where the Kalyani is situated? Or the map, does it highlight?
No, this photograph.
The photographs do not show anything.
This is the Kalyani and this is the tank.
It is kept open.
So the tank water does not reach Kalyani.
Nothing at all. In
And
fact, we
Kalyani
fill-
water does not mix with the
in
tank
fact,
water.
we fill the water in Kalyani
It
whenever
should
the
be
occasion
closed,
arises.
because this honorable court, while passing the order, it should not be used as amphitheater, that should be closed. Para 10, he says he will close it. That is not done. That's why the rejoinder in the photograph.
Where is it said
Para 10,
that Kalyani should not be used?
amphitheater, it cannot be used as, I'll just read that to you. Lordship. Paragraph 15, you Lordship. Paragraph 50, page 56, subclass 3, your lordship. As admitted by both the parties, since the total area of the tank also is pending before the court, the 44 acres should be allowed to decrease, should not be allowed to decrease, and the authority shall ensure no individual group, political party shall be allowed to construct any permanent structure within the tank area, that is 71.8, and or to pollute the water either in the lake or in the Kalyani. The Kalyani, let them maintain, we have no objection, your lordship, because it is required for immersion purpose, another thing, as per page 50, paragraph 15. Now the photograph is discloses that they will not close it. It will be kept open, use it as an amphitheater. Once the amphitheater is public are permitted, it is a violation under section 12 of the case. That's what this Honorable Court observed in paragraph 15. It cannot be violated. Kindly see paragraph 15, your lordship. Though the order passed by the court on 21 November does not prohibit construction of Kalyani, it does not mean that the authority cannot grant permission to construct either a temporary idol or any construction near the bar under section 12. So, as rightly submitted by the Land Council, so as part, the construction of Kalyani water shall be used only for immersion of Ganesha and Durga idols and for further ritual purpose only after prior permission from the authority. So it should be closed. That's what the photograph says. It is not closed. It is kept open to see that use it as an amphitheater, as admitted in para 10 of the affidavit. So only these three issues, if they address it, they can be disposed of. So tomorrow again they are using this 26th, there will be a festival. Again they are going to use it for the purpose of, there is a provision under section 12 of the, and also specifically is there page 56. Authorities also shall not permit any individual, any group or any political party to use the tank area for recreation or celebration so as to ensure protection of the tank.
You can't use it as amphitheater.
It's not used, my lords. It's kept for that purpose. It's not used where the people come and there is no exhibition of art.
The order of the court is very clear. It says that it has to be filled with water.
No, it need not filled with water. We're using it as a Kalyani all the time. especially when it comes as
See,
a.
if you had to use it as amphitheater, then the
That's
water
what-
will have to be dried out.
There is no water there all any time. We only fill it that water with some when festivals are oncoming, my lords. When there is a Ganapati festival happening, we fill it with water.
But
It is not filled with water. at
reading
any
the
point.
conditions at 3, 4, 5 of the order, that is page number 56.
Yes, my lords.
Internal page number
Page number
7,
56.
it
Yes, my
prohibits you from doing so.
Yes, my lords. I mean,
It prohibits you from doing so. It has to be used for only immersion of
That's all.
idols, that's all. That's the only other activity, religious activity that you are permitted to.
my lords,
Use it as amphitheater by drying it up.
it is built as an amphitheater. It is not used as an amphitheater.
No, it's built as a
It is
kalyani.
built as a Kalyani which can be used as an amphitheater.
That's according to you, but that's not what the order says.
And last paragraph, your lordship, page
My lord,
57.
any activity that is to be permitted within the lake is not permitted by the BBMP. The permission is granted by another authority called the
You don't
KSTP.
mix up issues. The issue here is only pertaining to use of kalyani.
Yes.
Yes, my
He
lords.
is not agitating with regard to use of lake.
Yes, my lords.
The
Let
whole
them close
issue
it.
is
Let them
with
close it.
regard to use of kalyani.
Yes, my lords. Yes, my lords.
Okay.
Yes.
And the observation at 3, 4, 5 of the order, we can't examine the merits over here. We are just going to interpret 3, 4, and 5 of the order.
And in fact, last paragraph, your lordship, page number 57, your lordship. The court has specifically said to avoid litigation. Kindly see paragraph last. With the above direction, IA number of 23 is disposed of. The said direction are temporary
The
measures.
authorities shall ensure that granting permission for immersion of Ganesh and Durga idols and performance of traditional rituals of Chat Puja shall not construe to misuse the same for any other purpose.
Yes, my lords.
Reading along with 3 and 4 implies existence of water over there.
Very well, my lords. I shall file an affidavit to the effect that.
You can't use it as amphitheater.
I'll file an affidavit to that effect. A short
Max to
statement.
max, probably you can have some laser show, that's all.
Yes, sir.
It's quite at a distance.
Which
but
has
I'll
got
file an
nothing to
affidavit
do
that
with,
effect.
the area covered includes the Kalyani area.
It is not, now it is not, from the photo, it is not used as a Kalyani. That is the problem. Otherwise, I would not have approached this court.
It is not used as a Kalyani.
And
at
court
all.
has said last, don't go for litigation again. That's what the Sarva court at last paragraph specifically said.
It is a structure.
We
which is
hope
built
that they respond
to
to
act as a
BBMP.
Kalyani.
Not a
think
challenge
government.
this order, council.
I will file an affidavit to
And
the
this
effect.
is
my
not-
lords. I'll file an affidavit to that effect that will only be used as a
Or
Kalyani.
seek modification. The
Let
writ
them file a
petition is
better
disposed of or not yet disposed of?
No, my lords, that's a 38401 which is lying before the division bench. It's in the same matter, my lords.
Seek modification of the order. sir.
Filing from.
Yes, my lords, I'll take instruction, either file a modification or file for a affidavit in this sense.
Some short date may be given. But again, 26th, the Shivratri festival is coming. Again, they are going to permit it, your lordship.
We don't permit, my lords.
Last year-
It's a
last
different
year also it
authority
is
which
there.
permits these
I produced
activities.
with
In fact, we are only
affidavit.
custodians of the lake. This is a wrong presentation.
No,
but-
Kalyani cannot be used for the amphitheater. That's my response submission. That is what they permit last occasion also. Last year also same thing happened after the order.
Sir, it will be used for the purposes it has to be used.
Only it should be used only for the purpose of Kalyani, Ganesha festival, immersion, another thing. Because your lordship, it is not closed. That's what I'm responsible. If they close it, it cannot be used for any. That's
But
what.
understand public sentiments
sir.
also. Okay.
Grateful, my lords.
Short date. may be there.
Any date, my lords. After 27th, any date.
27th,
Yes, ma'am.
6th of March.
Great.
Please.
41. Naveen Chandravi.
For the petitioner,
My
lords
lords,
may see, there was an order passed by this honorable court, my lords, on 14th
lords.
August.
Prior to that, can I just show, my lords, what the core issue is? My lords, the order, which is the order which we have said that there's a contempt. Kindly see, my lords, ink page 56. Ink page 56, the operative portion. All the petitioners are
special education teachers. They teach children with disabilities in government schools. At Inc. page 56, para 10, they were on contract for about 15 years. Suddenly, the qualification was changed and B.Ed qualification was imposed, which we challenged. Thereafter, the learned single judge, para 10, may I read out? Inc. page 56, para 10. Accordingly, I am of the view that the impugned memorandum dated so-and-so and endorsement dated so-and-so produced as Annexure M are hereby set aside. In view of setting aside the aforementioned official memorandum issued by state government, respondent authorities are directed to reconsider the case of the petitioners for appointment to the post of the elementary course having requisite qualification in terms of the RCI Act, that is Rehabilitation Council of India Act. Respondent party shall complete the entire exercise within 3 months from the receipt of the order. So ultimately, the court said that the new qualifications of B.Ed were set aside. Qualifications as per RCI Act should be there, and for our applications to be reconsidered within 3 months. Out of the 17 petitioners who were all teachers, about 3 of them were actually given the post. 14 of them, our applications were not considered. We filed the contempt. In the contempt, we were asked, there was an order of this honorable court dated 12/8. May I kindly request my lords to see the 12/8/2024 order. My lords passed the order at 12/8, on 12/8/24. May I read from para 4 or para 3.1. Learned single judge took the view that incorporation of the additional qualification of B.Ed was not justified and said that it was quashed as per so-and-so. Para 4. Compliance affidavit is filed by one Shri so-and-so who is serving as State Project Director, Samagra Shikshana, Karnataka, in which copy of endorsement dated 28/6/24 is attached. Endorsement refers to order of Supreme Court in the aforementioned writ petition. It is inter-alia observed in the said endorsement that in order to serve as special teacher, if one possesses the required qualifications specified by Rehabilitation Council of India and said documents are submitted to the Office of State Project Director, as soon as possible, action will be taken. When learned senior advocate so-and-so for the complainant submitted that all the complainant's petitioners possess the certification from Rehabilitation Council of India, it was stated by learned additional advocate Srimati so-and-so that copies of the certification are given to her. The authorities shall be instructed in light of the same to examine whether petitioners possess the requisite qualification of RCI, and necessary steps thereafter shall be taken to give appointment if they are found to be possessing the RCI requirement. My lords, by this order, we submitted it, and if my lords may kindly see my reply dated 26/9. 26/9/2024. I submitted a reply, my lords. The latest reply dated 26/9. If my lords have found it, it says reply on behalf of complainants to the additional affidavit. Yes. In that reply, my lords, from page 12 onwards, my lords may see all the 14 petitioners, we submitted their RCI certificates. Kindly see, my lords, from page 12. Page 12 of that reply. It is of one Miss Vasanta. If my lords, just for us, my lords may see, for example, this is the RCI certificate, which titles her as a rehabilitation personnel. She is given a CRR number, and the qualification on the right-hand side, certificate in education of children with special needs. So she is qualified as per RCI. After all these certificates were given, in fact, 3 of them were given the posts. At page 29, 3 people were appointed. 3 of these petitioners out of 14. The Kannada document is at page 29. For my lords, the translated copy is at page 31. In September 24, on 3rd September 24, 3 persons, three of the petitioners were appointed as the special teachers. The English one is at page 31. So, which means when all of them have the same RCI certificate, they are qualified. Three of them were appointed. These three persons reported. In fact, even the reporting on duty, the letters are produced at page 35. They reported on duty. After reporting on to duty for about 4 or 5 days, they were asked to not come. So my submission, my lords, is when all these, the order says you should have Rehabilitation Council of India qualifications. We all have the RCI certificates, which we have submitted. Based on the submission, three of them have already been given appointments. They joined, then they have been removed. So therefore, it is a complete violation. My lords, from May, the next batch of government school academic year will start. There are children with disabilities who need this rehabilitation training by these special teachers. So my lords, they have to do the appointments. 3 months time was given as per the impugned order.
My lords, may
What
I?
more remains?
Last
May I-
time,
my
last time you.
Lords, may I take the order, my lords? May I submit this? There is some things which have to be brought. Lords, the qualification that is imposed by the Honorable Supreme Court is D.Ed. It is there in the very order. Your Lordship may kindly take page 55, para 9. It is there, my lords.
Back to the Supreme
No,
Court
no.
order. The Supreme Court order is
My
considered.
lords may
And
kindly
after
see the,
considered-
because there is, I have enclosed the Supreme Court order also, my lords. Your Lordship may kindly take page 55 of the order under contempt, paragraph 9, my lords.
My lords, we
May
can't
I
go
read
behind
that, my lords?
of
Following the
government
law,
signature.
madam,
Yes.
please, kind. Following the law declared by Honorable Apex Court in the aforementioned decision, when the Honorable Supreme Court has categorically stated that trained candidates of D.Ed are qualified to be appointed to teach the primary education up to 4th standard, and further it is observed that those teachers are well aware about the child psychology and have been trained under development of a child at a tender age, and the same is absent insofar as B.Ed. My lords, we had issued a notification which included D.Ed also. Therefore, this notification came to be challenged, and the orders were being passed wherein it, and further, my lords, I am of the view that incorporating additional qualification of B.Ed in the impugned memorandum by the respondent authorities is contrary to law and liable to be quashed. So the required qualification, my lords, is D.Ed along with the RCI card, my lords. Now, may I come to the affidavit, my lords, which I filed after the order being passed by this honorable court. We have collected all their certificates. We have examined, my lords. Your lordship may kindly take page 3 of the affidavit, my lords, wherein we have given a comparative statement. What is the educational qualification prescribed by the Honorable Supreme Court, and what is the educational qualification that they are having? Lords, we are bound by the orders passed by the Honorable Supreme Court, wherein there was a letter issued by the Minister of Education. Lordship may kindly take page 3, my lords. I've made a table, my lords, in paragraph 4. The first column is the educational qualification prescribed by Minister of Education, that is central government, pursuant to the orders passed by the Honorable Supreme Court. Lordship may kindly take page 3 of the affidavit, which is filed on, my lords, 13 September 2024, pursuant to the orders passed by this honorable court. 13 September, my lords. It's the second affidavit which has been filed, which yes. Copy, sir. Lords, page 3, my lords, the column, my lords. My lords, here in the first column, this is the educational qualification prescribed by Minister of Education in writ petition number 132 of 2016. There were directions issued by the Honorable Supreme Court. Your Lordship may kindly see D.Ed in special education from RCI approved institution with valid RCI CRR number or DLD with a recognized qualification from RCI approved institution equivalent to D.Ed in special education and possesses a valid RCI CRR number. These are the qualification prescribed, my lords. My lords may kindly take the next column, my lords. These are the qualification possessed by the 17 applicants in this writ petition. And your lordship may kindly see, they have this multi-category teacher training 1 year duration and add-on course of 6 months, which is not equivalent to this DED special education as prescribed by the Honorable Supreme Court. Your lordship may kindly take page 6, my lords, wherein the Honorable Supreme Court, the order has been annexed. On page 11, there is a direction, my lords, of the Honorable Supreme Court. Our attention has been invited. My lords may take page 11, my lords. The order, my lords, wherein it is, our attention has been invited to the communication issued by the Undersecretary to the Government of India, Minister of Education, Department of School Education and Literacy dated so-and-so, informing all the state governments and union territories about the acceptance of the recommendation made by the Rehabilitation Council of India by the department and urging the concerned unions, states, union territories to give effect to the said decision in the right earnest and adhere to the direction given by this court in judgment dated 28/10/2021. The communication reads as follows. The lords may kindly see the next page, and the qualifications are also mentioned here. Very clearly it says for foundation, that is stage 1, preschool 1 and 2, primary level, the education qualification is D.Ed in special education from RCI approved institution. And second also, so 3 to 5, class 3 to 5, it is D.Ed LD with a recognized qualification, certificate, diploma. Lords, these are the qualification that has been prescribed by the Ministry of Education pursuant to the Supreme Court order, my lords. Therefore, we have considered all their certificate, and I have page 3, I have already culled out what is the educational qualification that they are possessing. And in view of that, they are not eligible to be appointed as special teachers, my lords.
What about those who have been appointed? They have.
My lords, this is only for 1 year, my lords. It's a 1 year contract basis. Every April that they are appointed, and May they are, 1 year it comes to an end. Those 3 of them who have been given appointment the very same day, my lords, it was withdrawn because of the, we are bound by the Honorable Supreme Court's decision. Therefore, my lords, we have also at page, next page, my lords, we have written to the Ministry of Education seeking for clarification. If at all they are eligible, can we appoint them? If at all we receive any information, my lords, or clarification, my lords, we are ready to appoint them, my lords. Not that, but we are bound by this order, my lords, of the Honorable Supreme Court. This all is my submission.
May I just respond? The order of the Honorable Supreme Court was referred to by the learned single judge. It is not something that has not been referred to. After, in fact, what my learned friend has submitted is is actually not that detailed order. I have a copy of the detailed order. After referring to the Honorable Supreme Court, at para 10, the learned single judge says they should be appointed if they have the requisite qualification in terms of RCI Act. And that is also what was held by the Supreme Court, RCI Act. All of us, all 17 petitioners in the writ had the same qualification. 3 of them were already appointed. In fact, they were appointed. That's why they didn't file the contempt. Contempt is only by 14. 3 of them have been appointed on contract and renewed. We were all on contract, and we are not seeking anything more than even a contractual thing. After this Honorable Court said, submit the RCI certificates, we submitted it by the 12/8 order. Thereafter, they appointed 3 more. Now, then they withdrew. Is it not something, they have not challenged this order? So can they now say, now we are going by the Supreme Court order. Supreme Court order, there is no grievance with. All of that has been taken into account and ordered by the Honorable Single Judge, saying that RCI qualifications. I have the RCI certificate. Whether it is DED, whether it is the multidisciplinary course, there is an RCI recognition. I've got an RCI certificate. All the ones who were appointed are having the same. So therefore, my lords, even till today, there is vacancy, there is a severe shortage of rehabilitation teachers, special teachers for children with disabilities. So what is the need to not comply with this? They've not challenged it. They can seek a clarification if they want to challenge it. They have not challenged it. From the time of this order, my lords, from when the order was passed, there is no challenge. Why should we, my lords? We have got an RCI qualification. It is only for government school sector for children with disabilities. We are without a job. Children with disabilities are without teachers. And when 3 are appointed under the order, thereafter 3 more are appointed, can they say they made an error? Are they saying, oh, we appointed them and then we withdrew? We all have the RCI qualifications. In fact, just one affidavit, they filed 2 affidavits. First affidavit, my lords may see, affidavit dated 2/7/24. My lords, apologies, I'm just troubling my lords. If my lord sees the compliance affidavit dated 2/7/24, if my lords could find that. 2/7, my lords have found that. In that, just above para 4, page 5 of the affidavit dated 2/7/24, it is the first compliance affidavit that the state filed. Internal page 5, above para 4. There is para 4 and then there is a table. Yes, just the line above para 4. They write, accordingly, now to work as special teacher, the person should have qualifications prescribed by RCI and have a valid RCI CRR number. Currently, the same standard is being followed. First, they file an affidavit saying that you should have RCI CRR number and an RCI certificate. I have that. I have the RC. What I have submitted are certificates with the CRR number. First, they say that. In the second affidavit, thereafter, after my lords, in fact, said, okay, you submit it if you have it, and they have to reconsider, and they have to consider. After that, they file a second affidavit, which my friend read out, saying that now you have to have some other order issued by Government of India. Government of India can issue any orders. We are only concerned with RCI, Rehabilitation Council of India, as per the judgment. Judgment doesn't talk of what Government of India may issue any letter.
Lords, para 9 very clearly, learned single judge says it is only the DED, only the
Para
DED
10 is the
qualification.
operative order. All
Lords, may
that is
kindly
taken
see
into
para
consideration.
9. Very clearly, the Honorable Single Judge says the DED alone are qualified to be appointed to teach the primary education up to 4th standard. It's very
Yeah.
clear. So we have to read along with this, my lords. Para 10 to be read along with para 9.
Apologies, my lords. May just see, just after that order, page 59, which is the RCI qualifications, page 59 of the paper book. In fact, the impugned order was at page 56. Page 59 is the, in fact, the cover letter starts from page 58, ink page 58 of the paper book. This is the, page 58 is the cover letter. Yes, from the Rehabilitation Council of India, which says that these are the guidelines for the special teachers. Next page are the chart, page 59. Next page is the chart of the guidelines. And in the chart, my lords will see, first is preschool nursery, which we are not concerned with. Then elementary, primary, upper primary, which is what we are concerned with. We are teaching the elementary primary. There's a whole list of qualifications prescribed. Either 12th with 2-year DED, 12th with special education, DSC, etc. So there is in fact, D-Ed as one of the options. Kindly see the next page, my lords, page 60. Number 10, 12th pass with any RCI recognized qualification of minimum 1 year duration and 6 months certificate course in education of children with special needs. These are all or. Para 9, which the Supreme Court said about D-Ed, was between D-Ed versus B-Ed. Initially, D-Ed or the special courses by RCI were considered as qualifications for special teachers. Government changed it and made it B.Ed. That the Supreme Court said there is no requirement for B.Ed for primary. And thereafter, reading para 9 and 10, what the Honorable Single Judge said, you have to go by RCI. Yes, if I have 12th plus D.Ed is also, I will get RCI certificate. If I have 12th plus the RCI course, I will
Where
also
you sought clarification from?
My lords, we have sought from Ministry of Education, my lords.
My lords, we have
When are
to
you expecting?
decide this before the year starts.
My lords, what my learned friend mentioned that MC,
No, when are you expecting that clarification?
Lords, we have written to them, probably they are also bound by the Honorable Supreme Court's decision, my lords. Very clear, my lords. It is a direction issue to all states. It is a direction issue to all states to follow these directions.
Last time you said that you are going to appoint.
Yes.
My lords, last time, my lords, we said we will reconsider as per the requisite qualification. Lords, it was examined. We called all of them. Their certificates were examined. But we are bound by the direction issued by the Honorable Supreme Court that they have to have the D.Ed qualification. They had this 1 year qualification of MCTT, which we cannot consider.
It doesn't say D.Ed, it says RCI. And D.Ed is one of the options. In fact, the learned Supreme Court, that is what the learned single judge has taken into account. My lords, no heavens are going to fall if we are appointed and the children are taught and we are given a job as per the orders.
He'll be in contempt of Honorable Supreme Court's order, my lords, is all. If there is a clarification, then we will follow, my lords.
There is a single judge's order. Can this Honorable High Court violate a Supreme Court order? If my learned
Single judge also has held D.Ed alone only can be appointed, my lords. Very clearly he mentions in paragraph 9.
Yes, this is the order. Just give this, yeah. Just give. This is the entire decision in Rajneesh Kumar Pandey of 2021. Kindly see, my lords, para 72. Kindly see para 72. Para 72, as regards the appointment, my lords found that. As regards the appointment of special educators, special teachers, rehabilitation professionals on itinerant basis under clause 4.3.2 of the SSS. This is the Sarva Siksha mandate, my lords. The same may not appear to be in strict conformity with section 25.2 of the 2009 Act. However, such teachers are not to be posted in a school as such, but are to render their services in a cluster of schools, which is permissible in the context of special teachers under the 1992 Act and the 1999 Act. Thereafter, my lords, the mandate is that children with special needs must be educated and trained only by special teachers, being rehabilitation professionals, duly recognized and registered by the council under the 1992 Act, which is a Rehabilitation Council of India Act. So the rehabilitation teachers are those who will be recognized and registered under the 1992 Rehabilitation Council of India Act. And in fact, they go on to say, my lords may see the next page, para 76. Para 76, they go on to say, in view of the above, a multi-pronged approach needs to be adopted by concerned authorities with immediate effect, and the directions are given. And para D and E, To overcome shortage of resource persons, rehabilitation professionals and special trained teachers, training schools, institutions must take steps to augment their number. E, until sufficient number of special teachers become available for general schools and special schools, services of special trained teachers can be availed as itinerant teachers. So there is such an urgency to appoint special teachers or special professionals. My lords, there is vacancy. Let my learned friend says they have enough teachers. Let's say they have enough
Lords,
teachers.
if there is a clarification, my lords, we can even now appoint, my lords. We are bound by this order and the letter issued by the Ministry of Education, my lords. That's all I'm submitting. There is vacancy and the year is coming to an end and the next round of appointments have to be done for the next academic year, my lords.
Let us not lose out, is what we are saying. The learned single judge's order has not been challenged. They can't hide behind some clarification sent to the government, central government. Central government's
Yes.
order is not to be, is not the
It's a
subject.
it's a part of the order passed by the Honorable Supreme Court. It has been culled out. The very letter has been culled out in the order, my lords. Page 12.
We are in my lord's hands, my lords. My lords are in fact, even on the last occasion said, submit your applications with the certificates of the RCI and they will take steps. Thereafter, they appoint 3, which shows that in fact, at the district level, they have appointed because they have the certificate. Then they suddenly realize and they back out because they realize that since they have made a mistake, they will then have to appoint the rest. What they are relying now on is a Government of India letter. My lords, Government of India letter may make any statement.
That's
The learned single judge, this is a contempt petition, taking into account even the Honorable Supreme Court direction stated RCI qualifications. I have an RCI certificate. When I have an RCI certificate, where is the question of violating either the Honorable Supreme Court order or the learned single judge's order? They neither challenge it. It has been a year and a half, 2 years.
So there is a finding by learned single judge that having the requisite qualification in terms of arts.
Yes.
How do you get out of
Lords, paragraph 9, my lords.
10?
Paragraph 9, my lords. It may be read along with para 9, where he states that D.Ed alone are to be qualified to be appointed.
My lords, if I can clarify, para 9 was in the context, D.Ed alone is, the challenge was because they had put a B.Ed qualification. Therefore, the learned single judge said,
We are also in teeth of this order, my lords. I'm sorry. We are also in the
No,
teeth of this order.
No, let me submit.
D.Ed are alone qualified, my lords.
D.Ed and D.Ed is stated in the context of B.Ed, is my submission. Because the RCI qualifications give at least about 10 optional qualifications. One of them is D.Ed. One of them is a multi-certificate course. The challenge was to, can you impose a B.Ed qualification? Therefore, the Honorable Learned Single Judge said, you can't have B.Ed. For primary, you can only have D.Ed if required. And then the RCI qualifications give a whole range. If I'm not qualified, where will I get it? And para 10 says you should have an RCI qualification. Yes, that's all that is required. Let contempt charges be framed, my lords.
Good orders.
Obliged.
list after something, after 10 years. When you put 20, today is 28, 27. 27.
Great. Great. 27.
27.
Great.
Mention serial number 67, my lord, some urgency in this matter, my lord. It has come for process, my lord. It is not required, my lord. We served the copy to all the respondents, my lord. Response are represented by advocate, my lord. 67. Respondent 2 is appeared by the advocate, my lord, BDM, my lord. Respondent number 3, my lord, who died during the writ petition itself, my lord. Paper publication was taken, my lord. Service are sufficient is held in the writ petition itself. Respondent number 12, 8 to 11 are appearing, my lord. 12 is also the same advocate is appearing, my lord. One more service held sufficient maybe.
So give copy
By
to.
next week, there is some urgency in the matter.
Your Lordship, serial number 81.
Give copy to the council.
No, no.
Give copy, Mr. Give copy, will dispense with the upper learned
Yes,
council.
yes.
Learned advocate for the appellant shall give copy of the. Whom? To whom?
R2, my lord.
Counsel for R2 appeared at you appeared before the learned single judge.
He is appearing, his name is shown.
In that view, the office of objection is dispensed. The appeal may be listed on 6th March.
Not.
Your Lordship, serial number 64, Your Lordship, 2 weeks time required.
Your Lordship, serial number
Cannot be
81.
25th, 25th.
Your Lordship, serial number 81.
3 and 4 are notes. So whoever is not served, you give copy.
It is everybody served, man. Respondent 2 is already appeared, advocate is on record, is already.
Your Lordship, serial number 81. Your Lordship, with regard to the additional documents, Your Lordship, the petitioner number 1 had filed a writ of mandamus, not making us a party, Your Lordship. And wherefore, to the said order, we have filed recall reopen application. It is those documents. Your Lordship, in the trial court, the matter is posted for arguments. They've already changed the kata, and wherefore it is very much urgent to do the hearing, Your Lordship. It may be kindly posted. Short accommodation.
4th,
The office objections may be overruled and it may be.
4th March, for that time, the office of objection shall be removed. 4th March.
4th March. Great.
Serial number
Lordship's kind
82.
permission. Serial number 46, I appear for accused BBMP. We have preferred a writ appeal, my lord. It may be connected with that, my lord.
Serial number 82, Your Lordship. We had filed a dispensing application. There's an objection pending for certified copy of the tender document. We need 45 days time to procure the certified copy. If this court allows us to be if it's dispensed, then it can be heard sometime in the next week.
Remove the office.
Obliged.